Banks is scheduled to enter a plea today. We did send the paperwork over to Sergeant Norris, but I have not received the paperwork back as of yet. So we may want to table this one.
Officer Norris is not here, but if you can send it to Sergeant Johnson, she can print it off for me, and then I will get it.
Okay, will do. Thank you. And my apologies. I didn't realize Sergeant Norris wasn't there today.
Okay, so can we go to someone else while we're getting that paperwork complete?
Position number 3, Mr. Boone.
Good afternoon, Mr. Boone. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Boone, you've been charged in case 23 CR 002153Y with battery family violence. Who do we have on from pretrial?
Good afternoon, Judge Caprice Clowney with Howard and Arca on behalf of Mr. Boone.
Yes, good afternoon. Who do we have on from pretrial? Okay, it doesn't appear that pretrial is on yet. Do you have the history, Ms. Falk?
I do, Your Honor. The defendant only has one previous arrest, and that was for possession of drug paraphernalia.
Okay, thank you. You can continue.
Yes, Your Honor. This incident happened April 8th, 2023 at 3:07 a.m. at 476 Wilmer Street Northeast. Officers spoke with Jadrian Elwood, that is Jadrienne, Elwood, ELWOOD, who stated that she and the defendant, her live-in boyfriend at the time, went out to a bar, and Miss Elwood wanted to leave, which made the defendant angry. Miss Elwood walked home, and when the defendant arrived a few hours later, they began arguing again, and the defendant struck her in the... I'm sorry, we appear to be getting a little bit of feedback. Okay, they began arguing again, and the defendant struck her in the face with a closed fist repeatedly. Miss Elwood's upper lip and left cheek were swollen and bruised, and the officers were able to observe that. And also, Miss Elwood stated that the defendant shoved her against a wall, causing pain to her head and swelling. Miss Elwood was able to escape the residence and went to Miss King's apartment, who is a nearby neighbor, and Miss King helped her by calling the police. The defendant was located after the parents arrived at the residence. The defendant's parents arrived at the residence and helped officers locate the defendant. We did have an opportunity to speak with Miss Elwood. She stated she and the defendant are in a relationship. They live together at the incident location and they share no children. She did confirm what happened in the warrant and stated she did not seek medical attention. She also stated this has never happened before. She further stated she is not in fear of the defendant. However, we do have some serious concerns about this incident, being that Miss Elwood had to flee the house and actually go to a neighbor's and seek out assistance from a next door neighbor to call the police. And for those reasons, the state is requesting a $4,000 surety bond, stay away from 476 Wilmer Street, no further contact with Jadrian Elwood, no alcohol, drugs, or weapons, and 1 day anger awareness. In speaking with Ms. Elwood, it appears that the defendant would be able to stay with his parents if he is not permitted to return to the residence. And again, given the incident that happened and our concerns regarding there being a serious lack of cooling off period, it's only been about a day and a half. We are asking that there be a stay away entered in this case. We also would like to sound from Ms. Elwood.
Okay. Ms. Elwood, if you are on the line, I'm happy to give you the opportunity to speak if you choose. You do not have to speak, but if you would like to speak, I will give you that opportunity. I don't see Ms. Elwood, Ms. Falk.
Okay, thank you.
Counsel?
Yes, Mr. Boone is 26 years old. He is a psychology major, currently in the process of completing his bachelor's degree. He does reside currently, well, up to this date, with his girlfriend, the alleged victim in this matter, but he is making arrangements to move in with his parents. He is born here in Atlanta, Georgia, and as previously stated, he has no significant criminal history. I believe the charge that was mentioned was actually expunged. So he is not a danger to the community. He's not a flight risk, and he's not likely to intimidate the witness. So we just ask that a reasonable bond be set.
Okay. And I take it that there's no objection to no further contact and a stay away, as I didn't hear anything regarding that.
No objection, Your Honor.
Okay, it's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further contact at this time with Ms. Elwood. Stay away from the 476 Wilmer Street address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond.
Thank you, Judge.
All right, good luck to you, Mr. Boone.
And that concludes my business before the court. Might be excused.
Yes, have a good afternoon. Thank you.
You as well.
And Your Honor, if courtroom 2 could just check their chat for a message I needed to send to them.
Are we ready for the next one?
Yes, we are.
Position 4, Mr. Curtis.
Good afternoon, Mr. Curtis. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Curtis, you've been charged in case 23 CR 0021798 with disorderly conduct and criminal trespass. Is pretrial on yet? Okay, do you have the history, Ms. Falk? And let's see, before you go, Ms. Falk, could we, Ms. Grace, or I'm not sure who, is it Ms. Bridgewater today? Would one of you see if pretrial is going to be on with us? It's 2:07 and they're normally here by now.
I will. Thank you, Judge.
Thank you. I appreciate it, Ms. Bridgewater. Good afternoon.
And Your Honor, we're also missing Miss Duncan, who, this is her case. I can address it, but she is also missing from our chat.
Is this not here? I thought I see it.
I'm sorry, I'm here. I didn't hear the position number.
My apologies. I did not see her and I got a little worried.
Okay.
Jonathan Curtis.
Okay. One moment. Let me get to that case. Curtis.
And apparently in the chat, pretrial just said that they are here. The audio isn't working.
Okay, thank you.
Sorry, my computer is freezing. I'm having technical difficulties. One moment. I beg the court's indulgence. And this is Curtis, correct?
That's correct.
In this case, Your Honor, it did occur on giving me the blues. One moment. All right. This incident did occur on April 9th, 2023, at 1005 Kingswood Place in Alpharetta. This defendant went into the it was the hotel, and he was refused services because he asked to have a room to take a shower, and they told him at that time at the Comfort Inn and Suites that he didn't have a reservation, so that they couldn't provide him any services. When they told him he was not going to be allowed to have services at the location, he became very belligerent with desk employees, yelling about his sexual health status and other things, as well as propositioning patrons of the facility. At that time, he was told to leave. He did in fact leave at that time. However, he did come back into the hotel, and he did in fact spit on the cookies that were there for the patrons to partake in. And given the information that he had provided, and given the current climate of our society, those cookies were no longer safe for patrons to consume. That's the factual basis for this incident, Your Honor. I do see in his history, since we don't have pretrial, he is a multi-state offender. He has several arrests out of Louisiana. He has arrests out of, he also has arrests out of Nevada, but those are remote. And as far as Georgia goes, they are, I'm sorry, he also has arrests out of Arkansas. And if I get to Georgia, it looks like Georgia has this as this defendant's first arrest. However, we do have some concern about the risk of reoffense, given that this defendant is a multi-state offender and the nature of the allegations as alleged. He acted this way, even though he didn't have a reservation and he made those remarks to customers and employees. So for those reasons, Your Honor, in this case, there is a preset $1,000 surety bond on the disorderly conduct. However, we have added the criminal trespass. So the state's recommendation in this case is going to be a $2,000 total surety. Stay away from the Comfort Inn and Suites at the incident location. As stated on the record, no further contact with any of the employees at that location. No alcohol, drugs, or weapons, one-day anger awareness, and no further violations.
It's going to be $1,000 signature bond through the jail on each count, which makes it a $2,000 signature bond through the jail. Stay away from the Comfort Inn Suites on Kingswood Drive and the employees that work there. No drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
All right. Good luck to you, Mr. Curtis. Who do we have next?
Next, we have position number 9, Mr. Feliciano.
Good afternoon, Mr. Feliciano. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 002174Y with simple battery family violence. Is there a history, Ms. Boxley Chester? As pretrial?
Can you just give me one moment, Your Honor? I'm just having technical difficulties.
Okay. We can come back, Ms. Boxley Chester. Ms. Duncan, do you have the history?
I have that this defendant has 7 arrest cycles. I had a driving conviction in 2019, as well as a controlled substance NOLO conviction in 2019, and a forgery in the 4th 2019, as well as a 2018 FJ 2020 probation violation and a 2021 entering auto and possession of tools arrest out of Gwinnett that the disposition just stated that it was indicted. This offense did occur at 5075 North Bridges Drive. Officers were dispatched to that location in reference to a dispute that had occurred in Johns Creek. When they got there, they met with a Caroline Coronado who indicated that she was outside of the lower level and that the defendant in this case was gone. Officers observed that Ms. Coronado's left hand was bandaged and she was refusing medical attention at that time. She stated to officers that on this particular date, this defendant only pushed her. But previously on the 7th, he had broken her hand. During the conversation with officers, she did indicate that during the previous altercation with the defendant, she lost consciousness. We have some concerns here, given that there seems to be a continued pattern of violence between these parties. I do believe that it was indicated that these parties may live together. There was an independent third party on the scene, a Jennifer Sierra, who was able to confirm that she did in fact hear the defendant and the victim, Ms. Coronado, arguing prior to him pushing and throwing her around the room before gathering his belongings and leaving. She did write a written statement to officers, and the victim's name in this case is Caroline. That's Caroline Coronado, Coronado. I'm not sure if she's on the line. However, the state would like the court to sound for her when appropriate. Given the nature of the offenses alleged in this case, Your Honor, we have concerns about the risk of reoffense in this case and possible intimidation of this witness, as well as his flight risk given the recent FTAs and some concerns about his likelihood to positively respond to the legal process. For these reasons, Your Honor, we're requesting a $4,000 surety, no further contact with the victim in this case, third-party child contact if they have children, stay away from the incident location, one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Ms. Kim?
Your Honor, I believe the Caroline Coronel was going to be on the Zoom because I had a chance to speak with her before the hearing. Oh, okay.
Okay, would you like for me to address her first, Ms. Kim?
Yes, Your Honor.
Okay, Ms. Coronado, if you would like to address the court, I need for you to activate your camera for the court, please.
Okay.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
I'm not afraid of him. I am not. It was just an incident we had as a relationship. He does have kids, so I do think that he does care. It was just a bad moment in a big fight that just overlead that was unnecessary and uncalled for.
Okay, there was some testimony or information that this is not the first time that this has happened. Is that true?
Yes, sir.
And there was also some allegation that he broke your hand the day before. Is that true?
I was intoxicated, so I really wouldn't know if he did or if I failed and did it myself. But it happened when we were fighting, so I was intoxicated, so I wouldn't remember.
Okay, and do you all have children together?
Yes, sir.
All right. And anything further?
No, sir.
All right, Ms. Kim?
Yes, Your Honor. Mr. Feliciano Onofre was born in Puerto Rico, but he moved to Georgia 2014, successfully graduated from Marietta High School. And right now he's gainfully employed as a tow truck driver. And he's the sole provider for the family of him and Miss Caroline here, and baby mother, and 4 children. They are 4 years old, 3 years old, 1.5, and 6-month-old, Your Honor. So it is very important for him to keep his job to continuously pay for his children. We would like to request for a signature on bond, and yet if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 good bond, Your Honor. Thanks.
So today, I'm not going to let Mr. Feliciano go back into the home with those children and with the allegations from Ms. Coronado. As such, it's going to be a $2,000 good bond, no further contact with Ms. Coronado at this time. Stay away from the Northbridge Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. Of course, I'm not going to keep him from seeing his children, but he can only have third-party transfer those children for visitation at the present time. No drugs, no alcohol or weapons while out on bond. All right, good luck to you both.
Next, we have petition 13, Mr. Clasper.
Okay, and while we're having him come up, Bridget Lucky, Ms. Lucky, number one, you should not be driving a vehicle and on camera. I understand, I don't know if you have someone here, but whatever you're doing is very disruptive to this court. You're to treat this court as if you are actually in court with me this afternoon. So I'm either gonna have to get you to go off camera or you're gonna have to pull over so that you can safely address the court in time. But whatever you're doing there, ma'am, is distracting for the court, and we ask that you stop.
I didn't know that you could see me. I apologize. I came from South Carolina to help my son. I was notified that my son was there, and I came all the way from South Carolina.
All right,
I'll have to pull over.
You'll need to pull over for the safety of yourself and other people that are around you, and we will try to
make it there.
Okay, well, we're doing this virtual, so you can be here virtually, but I can't have you endangering the lives of people on the roadway.
Safe place to pull over.
Okay, you do that. Thank you, ma'am.
I understand.
Okay, I appreciate it. You're welcome. I'm sorry, who do we have in courtroom 2 again?
Position 13, Mr. Clasper.
Hey, good afternoon, Mr. Glassman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. You've been charged in case 23 CR 002155Y with improper erratic lane change and driving under the influence of multiple substances. Is there a history, Ms. Boxley Chester?
This appears to be the defendant's first arrest out of Georgia, and it looks like he has 4 cycles and no convictions out of Indiana. I don't know. It's fine. And there's nothing further.
Okay, Ms. Falk?
I am showing something a little different. I am showing a history out of Gary, Indiana, but I'm also showing he was released on an involuntary manslaughter case in 2023. And so the 4 appear to be all stemming from the same case, but I can't be sure. It looks like it may have started out as one charge and then evolved until he was released in 2023 on an involuntary manslaughter charge. So that's what I'm seeing when I looked at the history. This incident happened April 10th, 2023 at 10 p.m. at Holcomb Bridges Road and Eves Road. The defendant was driving about 15 miles per hour on Holcomb Bridge Road and was swerving across the lanes of traffic. An officer observed him driving at this rate of speed and driving in this manner and began following him until they reached Steeplechase Drive. While the officer was following him, he observed the defendant going 19 miles per hour in a 45 mile per hour zone. He saw the defendant repeatedly engage his brakes and swerve into the right adjacent lane. Finally, the officer initiated a stop. The defendant was extremely disoriented, exhibited slow and incoherent speech, and stated he did not know where he was and asked the officer what state they were in. When asked, the defendant stated he was going to Ohio. He was actually traveling in the opposite direction of Ohio, and he was sweaty and his eyes were red and glassy. When the officer asked him if he had had any substances or had anything to drink, the defendant did admit to smoking marijuana, drinking what he said was a little bit of alcohol, and ingesting MDMA, otherwise known as ecstasy, prior to driving. The defendant did fail the field sobriety test and was placed under arrest. Given the circumstances, Your Honor, this was a pretty serious offense. It's 10 p.m. on Holcomb Bridge Road, which is a well-traveled road. The defendant was extremely intoxicated based on not even knowing what state he was in at the time of the offense, and could have put multiple people in danger by his manner of driving, including swerving all over the roadway. The state is asking for a $5,000 surety bond, $4,000 for the DUI, $1,000 for failure to maintain lane, no alcohol, drugs, or weapons, and no driving whatsoever. Thank you.
Thank you, Your Honor. My client is 40 years old. According to the pretrial report, his last arrest was 2006. I'm not sure what his prior convictions or arrests were based on what was proffered today. He is actually from Cleveland, Ohio. He is currently unemployed. However, he does have 4 children that he does take care of. that live in the home with him, an 8-year-old, a 7-year-old, a 5-year-old, and a 4-year-old. Sorry, what's going off? He said that he was just visiting Georgia. And so we would request a signature bond, and if your honor is not inclined, we would ask for $1,000 surety bond.
And Your Honor, I did have an opportunity to look at cycle 4 again, which is the last cycle in his cases out of Ohio. And under cycle 4, it says supervision date June 21st, 2007. Under correction action, it says incarceration. And then under correction comment, it says remarks, involuntary manslaughter, carrying a handgun without a license, and battery. And it also says the agency was the Reception Diagnostic Center, which are all indications that he was at some point incarcerated.
Good. A $1,500 good bond, a total of a $2,000 good bond, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Glasper. Who do we have next?
Next, we have position 22 and 23, Mr. Parks, Quintavious Parks. Quintavious Parks.
Yes, good afternoon, Mr. Parks. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Moses Counts, is this your case?
Yes, it is. Good afternoon, Your Honor.
Good afternoon. In one case, I have his name as Gabriel Parks, and in the other case, I have it as Quintavious Parks. Is that correct? Or
I was told that these were two totally different individuals, and they do have two different mugshots. They're two.
Oh, okay.
Yeah, but that Gabriel Parks was never brought up for me to speak to, so I don't know if he's actually here today.
Okay, so this is Quintavious Parks.
Yes.
Okay, thank you. That was just confusing for me. Okay. Mr. Parks, you have been charged in case 23 CR 0021688J with too fast for conditions, reckless stunt driving, driving in circular or zigzag course lane drags, driving on the wrong side of the road, improper erratic lane change, failure to obey signs or control devices, a seatbelt violation, and failure to signal lane change or turn. Is there a history, Ms. Boxley-Chester?
Yes, Your Honor. The defendant has 4 cycles. Defendant doesn't have any felony convictions. Defendant has 1 misdemeanor, affixing materials that reduce or increase light transmission, reflection of windows, windshields, and that was in 2022. And nothing further, Your Honor.
Okay, thank you. Ms. Falk?
Yes, Your Honor. And this incident happened on April 2nd of 2023. Officers had been monitoring this defendant based on a prior vehicular homicide case that he was on bond on. They observed on his YouTube account, which belonged to him, that the defendant was driving at 100 Lakewood Way Southeast, and he was driving a 2021 Dodge Charger. In the video, it showed him going 101 miles per hour on Lakewood Avenue, and he was not wearing his seatbelt. Using the video from the defendant's YouTube account, they were then able to use the cameras at those locations to observe the defendant in that 2021 Dodge Charger, getting off the highway, making a right turn on the wrong side of the exit, burning the rear tires, leaving skid marks. The defendant was also seen on camera running a red light on Lakewood Way. My understanding from talking to the officer is the ankle monitor that the defendant was on his 20 CP case was also used to help ascertain his location at the time of these offenses. So the defendant is currently out on a $62,000 surety bond on case 20 CP 195381, and that is for vehicular homicide in the first degree, reckless driving, speeding, and racing. That involved an incident August of 2020, where he was driving 134 miles per hour in a 45-mile-per-hour zone while racing on Oakley Industrial Boulevard in Fairburn. And during that was in an accident that killed Mr. Zawante Cuffey. The conditions of that bond, which are extremely important to this case, are that he was placed on a 24-hour curfew with the exceptions of work, school, and medical. He was placed on an ankle monitor, and he had a condition to have absolutely no driving. It was actually in all caps on the bond order. And he has clearly violated that both with this offense and I believe yes, he also had the offense from the affixing materials that reduced or increased light transmission on windshields. That actually happened in December of 2021. He was convicted of that in January of 2022, and that was also after that bond condition was imposed. So he's had not only one subsequent driving offense to this bond, but now he has this case. To that end, we are very concerned. This defendant is a serious risk of reoffense. He's already violating a very serious set of bond conditions on that 2020 case, which were put into place because he was engaged in the same behavior that he's alleged to be engaged in at this offense. For that reason, we are asking for a $10,000 surety bond per count for a total of an $80,000 surety bond, no driving with no exceptions, and which already was the requirements on his previous bond. And we're asking again for that 24-hour curfew to remain imposed, as well as the ankle monitor to remain on. Nothing further from the state.
Yes, Your Honor. My client is 23 years old. He does have a good address in Atlanta. He is a father of a 2-year-old that does reside in a home with him, who he does provide primary care for. He owns his own business. He does lawn service. And based on his income, he would not qualify for the services of the public defender after today. I understand that he has this prior vehicular case in which he's out on bond. He did notify that of me and was transparent about that when we spoke. Based on the fact that he does have significant ties here, I don't believe that he would be a flight risk. I would ask for your consideration of low of a bond as possible for him to be able to defend these charges.
And Your Honor, pardon me, I also do want to add that he had a arrest out of Tyrone Police Department on his history as well from February of 2022 for fleeing and attempting to elude a police officer, which would again be a driving offense that was done while he was already on bond. So he's got 2 new driving offenses, one he's been convicted for since he bonded out on that previous case.
For the reckless stunt driving, it's going to be a $7,500 good bond. For the laying drags, it's going to be a $7,500 good bond. For all of the other alleged violations, it's going to be a $1,000 good bond. So my calculations, that's a total of a $21,000 good bond. The 24-hour curfew will stay in effect. The no driving will stay in effect. The ankle monitor will stay in effect. And no drugs, alcohol, or weapons while out on bond.
Your Honor, you said the curfew is for what time?
Apparently he has a 24-hour curfew. Is that right, Ms. Falk?
That is correct. Let me double check on that previous bond condition, but I'm pretty sure the curfew they imposed was 24 hours except for to school, work, and attorneys.
Okay, so school, work, and attorneys are the exception. Otherwise, he is to remain at his residence.
Okay, so you said 7,500 good on the 2.
Right, on reckless stunt driving and laying drags.
Okay, and 1,000 on the others.
That's correct.
And yes, Your Honor, it's 24-hour curfew unless to school, work, court, and medical appointments.
Okay, with those exceptions. Thank you. All right, Mr. Parks. Good luck to you, sir.
Ms. Moses, please call 44612-2391. We're ready for Mr. Gabriel Parks.
Can you put that in the chat?
Not a problem.
Thank you.
Next, we have position number 6, Mr. Derek Dixon.
Good afternoon, Mr. Dixon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Did we have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Dixon, you've been charged in case 23 CR 002152B with 3 counts of theft by shoplifting. Is there a history, Ms. Boxley Chester?
Yes, the defendant has 2 cycles, which includes the case today, and he does not have any convictions. Nothing further.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This happened over the course of several days, November 19th and then November 26th, where 2 of the incidents happened. This occurred at Target at 5570 Roswell Road in Sandy Springs. On November 19th, the defendant took 13 Airwick refills with a value of $75.60. He switched the tags for a lesser price of $4.72 and then paid for them with a MasterCard that was registered to him in his name. This was also caught by surveillance cameras. November 26th, around 4 p.m., he went back to the same Target, took 15 Airwick refills with a value of $130.50, switched the tags on them again for a lesser price of $8.85, and then again paid for them with a MasterCard registered to his name. And then on November 26th at 6 p.m., he returned back, took 8 Airwick refills with a value of $86.40, switched the tags for a value of $7.67, and then paid for them with a MasterCard registered to him, again, all captured on surveillance video. I have no earthly idea what he needed with this many Airwick refills, but apparently he was in deep need of them. We do have that he was arrested in December of 2022 for theft by shoplifting. We did look up that case in municipal court. He completed Restore Atlanta, and his case was dismissed on March 17th of 2023. The state, there is actually currently a $4,500 surety bond on him, $1,500 on each charge. We're agreeable to reducing that to a $1,500 surety bond, $500 per charge. Stay away from the Target at 5570 Roswell Road in Sandy Springs, and no alcohol, drugs, or weapons. Thank you.
Your Honor, my client is 59 years old.
Ms. Wells, I'm about to give him a signature bond, but if you want to make your presentation, I'm happy to listen to it. Okay.
No, Your Honor.
Okay. All right, so it's going to be $1,000 signature bond through the jail on each count, making for a $3,000 signature bond through the jail. Stay away from the Target on Roswell Road, and no drugs, alcohol, weapons while out on bond. Good luck to you, Miss. Does that suit you, Ms. Wells?
Yes, the only thing we would ask for, he did say that he could have made his previous bond, but he doesn't have access to his wallet. And so I don't know if he needs any kind of information from his wallet or personal effects. So if he has access to that.
If his wallet is there at the jail, if they took it from him before he was signed in, they should give it back to him, I would imagine, once he is released.
No, he was saying he could have bonded out, but he didn't have access and he had information in there. So I'm not sure if he can have access to it, if he needs to fill out any paperwork or documents. That's all I'm asking for.
Okay, well, that would be a jail function, and I'm sure that if they have it and he needs that for whatever he needs it for, that they will provide it to him, given that it's his property and that he will be being released from jail. Okay?
Thank you.
All right.
Your Honor, really quick, is that through jail or through pretrial?
It's through the jail.
Okay.
If you're speaking, Mr. Dixon, you're on mute, sir. Yes, sir.
I just let you know, I just needed that to be able to get the money. I have to pay it myself.
Okay, well, I've given you a signature bond, sir, so you'll be able to sign yourself out. All right, good luck to you, sir.
Thank you, sir.
You're welcome.
Next, we have position number 8, Mr. Dwayne Albito.
And Your Honor, while they're bringing him up, if I can ask courtroom 2, can you give me the first name of the deputy you want me to send the paperwork to, just so I can send it? There are several people by that last name.
We just got Mr. Moore.
And if you can type it in the chat, or I can call over to the jail.
Would you need to send some paperwork to us?
The plea paperwork on position 2, yes.
Okay.
Thank you. I appreciate it. I see it in the chat. Thank you.
Okay, and is the last name Abuelito?
First name is Abuelito.
First name is
First name-
Abuelito,
okay, the last-
name is Dwayne.
Dwayne, okay, good afternoon, Mr. Dwayne. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 002154A with battery family violence. Is there a history?
Yes, Your Honor. This appears to be the defendant's first cycle out of Georgia. The defendant has 2 cycles out of Florida for battery, police officer, corrections, firefighter, but that disposition was abandoned. And nothing further, Your Honor.
Ms. Falk?
Yes, Your Honor. This happened on April 8th at around 5:15 a.m. at 6993 Roswell Road, Apartment H in Sandy Springs. Mr. Javiel Edmond, and the first name is Javael, stated that he and the defendant, who is his live-in boyfriend of 1 year, were arguing, and the defendant grabbed him and tried to remove him forcibly from the apartment that they shared. Mr. Edmond then defended himself and bit the defendant on the finger while the defendant was struggling with Mr. Edmond, trying to forcibly push him out. As a result of the defendant grabbing Mr. Edmond had scratches around his chest and his neck area. We did attempt to reach out to Mr. Edmond. Unfortunately, based on the information we had, the limited information we had in the warrant, we were not able to reach out to him at the several numbers that we attempted. The state's recommendation in this case is a $3,000 surety bond, no further contact with Javiel Edmond, no alcohol, drugs, or weapons, stay away from 6993 Roswell Road in Sandy Springs, and 1 day anger awareness. That's all for the state.
Your Honor, my client is 28 years old. His last arrest was in 2017. He is employed. He works at PF Chang's as a bartender and waiter, where he's been employed there for 6 years. And he reports that he recently paid all of the bills at his household. And so he does not have any money right now to bond out. So we are requesting a signature bond if possible.
Have you spoken with Mr. Evans?
I have not.
It's going to be $3,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with Mr. Edmond, stay away from the Roswell Road address. He can go back to that address on 1 occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Dwayne.
Next, we have position 11, Mr. Kelvin Floyd.
Good afternoon, Mr. Floyd. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Floyd, you've been charged in case 23 CR 002156G with battery family violence, 2 counts. Is there a history, Ms. Boxley Chester?
Just give me one moment, Your Honor.
While we're waiting for that, Ms. Falk, can you go ahead and give us your presentation, please?
Yes, Your Honor. I can also give the history if you need it.
Okay, that's fine. Thank you. Yes.
We're showing a 2015 ag stalking out of Cobb County that was dismissed, and a 2018 DUI that was reduced to reckless driving and convicted on 2019 in Carroll County. Those are the only 2 that I was showing on the history. The incident happened on April 9th, 2023 at 2:50 a.m. at 2422 Chattahoochee Circle in Roswell. Zoe Willis, Willis is common spelling, Zoe is Z-O-I-E, reported that the defendant pulled her hair, hit her with a closed fist in the face, scratched her face and arm, and struck her several times on the buttocks with a belt. We actually did receive photographs from Miss Willis showing some extensive bruising where she was struck with a belt. The officers also saw bruising and swelling to Miss Willis. The defendant and Miss Willis do live together at the residence. We did have an opportunity to speak with Miss Willis. She stated that this is not the first time this has happened, that she has called the police on him before, but no arrests were made, the defendant is very mean to her and she is intimidated by him. She also stated she's in fear of the defendant, does not know what he will do if he returns back to the residence. And she stated she wants the defendant to be able to speak with their daughter, but does not feel comfortable with him having the child by himself. She further stated she does not want him to return back to the residence, and therefore he will need, if Your Honor imposes the stay away, a one-time law enforcement escort to retrieve his belongings. The defendant has attempted to call Miss Willis several times from the jail. And at one point she did hang up on him and asked him why he continued to call her. The state's recommendation, due to our concerns about the risk of reoffense and the intimidation to Miss Willis, is a $6,000 surety bond. Stay away from 2422 Chattahoochee Circle, no further contact with Miss Willis, no alcohol, drugs, or weapons, and if Your Honor is willing to impose it, one-day anger awareness. That's all for the state.
Ms. Willis, let me see if Ms. Willis wants to speak.
In Your Honor, I was remiss in saying she is present at the Zoom.
Okay, you're fine, Ms. Falk. Ms. Willis, this is your opportunity to address the court if you choose to. You do not have to address the court, but if you choose to address the court, I need for you to activate your camera, and I'm going to have to swear you in if you would like to speak to me.
Okay, I'm fine. I don't.
Okay, hold on, Ms. Willis. I need for you to raise your right hand for me. I think that's the other right. Okay, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
The truth.
Okay. What would you like to tell the court?
I just want to say that, Kelvin, that what you've done and what has gone on, I'm not going to continue to throw salt on what's already been done. And I'm a God-fearing woman, and I'm going to take care of our daughter and do what I have to do to get myself together and move forward. And that's it. That's all I want to say.
Okay, thank you. Ms. Wills.
Yes, Your Honor. My client is 33 years old. As the state mentioned, he has one prior conviction, which was a traffic offense for reckless driving. He is married to Miss Willis. He is employed at Flatwoods as a delivery man. He is also a private investigator. He and Miss Willis have a 5-year-old daughter together. He states that Miss Willis suffers from some mental health conditions which led to this incident, and he adamantly denies the charges, and that it states that he was actually defending himself. He also states that he was asked whether or not by law enforcement when they arrived, whether or not he wanted to press charges, but he declined. So in light of that, we are asking for a signature bond. If Your Honor is not inclined to do so, we would request $8,000 surety bond.
Your Honor, I will also add that according to our conversation with Miss Willis, they are not married.
Yes, we are not married.
For each charge, making for a total of a $2,000 surety bond. no further contact with Ms. Willis, stay away from the Chattahoochee Circle address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. There's to be a third-party transfer of the child for visitation, and no drugs, alcohol, or weapons while out on bond. Mr. Floyd, I'm not going to keep you from your child, but I just want to let you know what no further contact means. It means no contact whatsoever. No phone contact, no personal contact, no email contact, no social media contact, no contact whatsoever. When you want to visit with your child, you're going to have to go through a third party who's going to have to arrange for that visitation. Okay, Mr. Floyd?
Yes, sir.
All right, good luck to you, sir.
Thank you.
Your Honor, the state would request if Your Honor is going to do a third-party transfer of children for visitation, given the concerns of Ms. Willis, we would ask that there be another adult supervising when he has contact with the child.
That was ordered.
I'm going to let the Superior Court deal with that. If they need to file something regarding the child, then they can do that. But at this point in time, there'll be third-party transfer, and I don't know what the other concerns are. If she has different concerns, she has a way that she can go about addressing those.
Yes, Your Honor.
Okay. All right. Good luck to you all.
The $2,000.
Next, it's position 14, Mr. Gonzalez. Stephen Gonzalez.
I actually submitted a waiver of appearance for Mr. Gonzalez.
Okay, so we don't need him, Miss Willis? You've already filed a formal waiver?
Yes.
Okay. So his appearance has been waived. We'll address this at the end of the calendar.
So what's going on with my pension?
Do we need to go into a breakout room, Miss Wills?
We can.
Okay, so we're not going to, let's hold on to doing that if we need to do that at the end of the calendar. A waiver has been filed, Officer Milton, so let's just go on to the next person, please.
Yes, Your Honor. Next, have a seat on the row, sir. Next, we have position 15, Mr. Happy. I'm sorry, I messed up your name. Have a seat, please.
Yes, good afternoon, sir. I'm Judge Eric Moyer. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 23 CR 002158G with simple battery. Is there a history?
This appears to be the defendant's first arrest, Your Honor.
Thank you. Ms. Falk?
Your Honor, this happened at Publix at 1100 Hammond Drive, Atlanta, yesterday at around 12:40 a.m. Officers responded to that location, saw a vehicle driving erratically through the parking lot before coming to a stop. They made contact with the driver, Ms. Tanin Ashtari, that is TANINASHTARI, who stated that the defendant, who she had been in a 2-year relationship with, had been hitting her, and they were arguing inside of his vehicle, which was parked beside her vehicle at the Publix. And she also stated the defendant literally kicked her out of the vehicle. Ryan Ashley, who was a security officer at that location, also stated he observed the defendant and Ms. Ashtari arguing and saw the defendant pull Ms. Ashtari out of the vehicle and throw her on the ground as they were arguing. Mr. Ashley further stated he saw Ms. Ashtari get into her vehicle and then drive off after she got up off the ground where the defendant had thrown her. We did have an opportunity to speak with Ms. Ashtari. She stated that they do not live together at any residence. They don't share any children. She also stated this had never happened before, and she did not want the defendant to be arrested and did not call the police. So the state's concern on this one is the fact that this was witnessed by a third party who has no dog in the fight. He was a security guard at that location, saw the defendant yank Miss Ashtari out of a vehicle, throw her to the ground, and she is now stating that she essentially doesn't want to proceed and is fine with everything that happened. But obviously, the security guard was not okay with it because there was a third party, and I don't know if it was or was not the security guard, but a third party ended up calling the police after witnessing this. So for those reasons, the state is asking for a $2,500 surety bond, no further contact with Tannen Ashtari, no alcohol, drugs, or weapons, and 1 day anger awareness. We would like the court to sound for Miss Ashtari and see if she is here.
See, if you would like to address the court, now is your opportunity to do so. You, of course, do not have to address the court, but if you would like to address the court, I'll need for you to unmute yourself and raise your right hand for me, ma'am. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
This was our first time really, him ever putting his hands on me. We were outside. It was a crazy night. We were having a crazy fight. He was just trying to get me out of the car, which is why he was like, just get out of my car. Open the door, was like, just get out. He pushed me out of the car, which I did get out. And then when I got in my own car to leave the Publix, I realized I could not drive. So I got back to the parking lot, and that's when the police officers came and asked me questions. But this was the first time that anything like this has ever happened to us in the past 2 years that we've been together, which is why I did not want to press any charges or have any issues.
Did you hear my question?
Yes, can you hear me?
Yes, can you hear me?
Yes. I'm sorry. Could you hear anything I've said?
No, yeah, I heard everything you said. My question to you was, are you afraid of him?
No, I am not.
Okay, and I believe that you stated that this has not happened before?
Never.
Okay, any questions, Ms. Falk?
Yes, Your Honor. Ms. Ashtari, you stated that you couldn't drive after this incident. Why?
Because when I fell down, I felt a little dizzy. So I turned around, I parked the car, and I told the officers, like, I cannot drive. And the officers asked me to call my father to come get me, which I did. I called my father and my brother. So they came, they picked me up, and they took my car.
And how long did it take them to come and get you?
It didn't take that long. I live one exit away at 4725 Village North Court. So it took them about 7 to 8 minutes.
Okay, and during that entire, I'm sorry, Ms. Ashtari, I did not mean to interrupt you. My apologies. During that entire time, were you still feeling dizziness and didn't feel safe to drive?
Yes, I was crying. Like I was just bawling my eyes out in the backseat of my car. And I just did not feel like getting behind the wheel to put other people in danger.
Okay. Thank you, Ms. Ashtari, and thank you for your answers today.
Of course.
Ms. Moses counts.
Thank you, Your Honor. My client is 23 years old. He does have a good address located in Alpharetta, Georgia. He is a student at the Institution of Art and Design in Sandy Springs, and he also is a barber at a local barber shop. Based on the income that he has, he would not qualify for the services of the public defender after today. Your Honor, he does have significant ties to the state as well. He's been present in the state for the past 10 years. And again, he is a student here, receiving a degree in art soon. Your Honor, I would ask for your consideration of a signature bond based on the fact that this is his first arrest. He has no criminal history, no other arrests. And based on the comments from Ms. Ashtari, this has never happened before. And again, he would like to move forward with this charge in court, whatever defenses he may have prior to the physical incident. I'll let that be at the next stage. But as for now, he has no criminal history. Ms. Ashtari is not afraid of him, and he does not have any anything that to me would resemble being a flight risk. And so based on that, I would ask for your consideration of a signature bond. Judge, your mic is going out. I can't really hear you.
I thought I was the only one. It's going in and out, Judge Morrow.
Can you hear me now?
It's
Can
like
you all
a
hear
muff.
me?
I can hear you
We
now.
can hear you now.
Slightly muffled, but I can hear you better.
$2,000 signature bond through pretrial per the judge, 1-day anger awareness, no further violent contact with Ms. Ashtari, and no drugs, alcohol, or weapons while out on bond.
Okay, so you said 2,000 signature bond through the jail?
Through pretrial per the judge,
Sure, okay.
1-day anger awareness, no further violent contact, and no drugs, alcohol, weapons. Okay?
Thank you.
All right, good luck to you, sir. You also, Ms. Ashtari.
Thank you.
Who do we have next?
Position 17, Michael Johnson.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. You've been charged in case 23 CR 002157C with battery. Is there a history?
Defendant has 3 cycles. Defendant has a misdemeanor simple battery family violence in 2018. And defendant has a probation violation that's in 2023. Nothing further, Your Honor.
Ms. Falk?
Yes, Your Honor, this happened April 8th, 2023 at approximately 11:30 p.m. Officers went out to 3378 Greenbrier Parkway Southwest, Unit 4007. They met with Mr. Willie Butts, and Mr. Johnson, who is the defendant, stated that Mr. Butts rang his Ring doorbell camera a number of times, insisted on using a lighter, and then came back to his apartment, rang the doorbell in order to find out where his niece, Miss Sadea Davis, was. Mr. Butts then stated to police that at that point, the defendant attacked him, swinging at him with a closed fist, which struck him in the eye, and the defendant did have, Mr. Butts did have swelling under his left eye and a bruise that was observed by the officers. They did have a chance to speak to Miss Sadea Davis, and Miss Davis advised that she was not on scene when the physical altercation took place. However, she did say the defendant called her numerous times, stating that he beat her uncle's ass outside on her patio. So for those reasons, we are asking, especially given the fact that he has a prior simple battery and a probation violation, we are concerned that he is a risk of reoffense and that he is not amenable to following the court's orders. For those reasons, we are asking for a $3,000 surety bond. We are asking for no further contact with Mr. Butts. We are also asking for a stay away order from the residence of Mr. Butts, which is 3378 Greenbrier Parkway Southwest, apartment 4007, no alcohol, drugs, or weapons, and 1-day anger management. We also would like to sound for Mr. Butts. We were not able to reach him using the numbers that we had available, but we would like to sound for him just in case he is in court today.
Mr. Butts, if you are with us and wish to address the court, now is your opportunity.
And can you repeat the stay away address you just requested?
So it is in the same apartment building where the defendant lives. It is a different apartment. So we're just asking that he stay away from that apartment. And that is apartment just a second. That's apartment 4007. We have Mr. Johnson's apartment is 4107.
Close this count.
Yes, Your Honor. As stated, my client is 57 years old and does have a good address that's already been stated on the record. My client is not employed, Your Honor. He would not have the means to pay a monetary bond. I do understand that he had a prior conviction with, which I am assuming is what is related to the probation violation, which I've only heard one of those. I don't think that's significant to say that he would be a flight risk. He's been present in the state since 2015 and has had at his age no other incidents here in Georgia criminally. And so I would ask still, this all started with this individual coming to his home, his residence, which I guess there will be some later defenses that Mr. Johnson could take up with his attorney. However, this was not instigated by my client. And so I would ask, based on that, for your consideration of a signature bond, because I do think he should qualify. Nothing further.
Your Honor, I can't hear you. You're going out again.
Can you hear me now?
Yes.
Okay. $5,000 signature bond through pretrial per the judge, 1 day anger awareness, no further contact with Mr. Butts, stay away from Mr. Butts's apartment, no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Johnson.
Thank you, Your Honor.
Next, we have position 18, Mr. Moore.
Good afternoon, Mr. Moore. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
All right, that's okay.
Okay. Good afternoon, sir. You've been charged in case 23 CR 002164E with criminal trespass. Is there a history?
Yes, this appears to be the defendant's first offense in Georgia. Defendant has one other cycle in Florida, and that is a open case for trespass property after warning and resisting officer without violence. And nothing further, Your Honor.
Okay. And I don't see anyone on camera who's representing Mr. Moore.
And Your Honor, it's my understanding that this is a pro se plea, and I have sent the paperwork too.
Okay. Mr. Moore, let's see. If you can unmute courtroom 2. Courtroom 2, can you unmute for me? Thank you. Mr. Moore, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We have provided you with the assistance of a public defender today. It's my understanding that you wish to proceed pro se without the advice of a lawyer. Is that correct?
Yeah, public attorney.
Yes, a public defender who would defend you at this point in time. We have offered you that option. You do not.
So
Say it again.
If I don't go with the attorney, would I get? I just have court today.
Well, it's my understanding that you wish to enter into a plea to criminal trespass. You understand that because of your history that you could get a signature bond on this charge and be able to come back at a later date to address the charges.
You got really kind of say what that is, because I ain't think it was trespass. Honestly,
Oh.
that's so real.
Okay, so Mr. Moore, I'm not gonna allow.
I ain't damaged anything.
Okay, so I'm not gonna, if you're telling me that you're not guilty of trespass, I'm not gonna allow you to plead guilty to trespass, okay? But do you want to speak with, would you like to speak with a lawyer to help advise you on this matter?
Well, we'll have to stay in here.
Well, I've heard your history. I have not heard what the criminal trespass is, but I can tell you that more than likely you're going to get a signature bond on this matter, and you'll be able to come back and address it at another time.
All right, so I believe, right? I'm trying to ask a question.
Say it again.
So I'll be able to come back another day, like I'll be able to leave or something, right?
Ms. Moses Counts, were you able to speak with Mr. Moore?
Yeah, Mr. Moore, can you stop talking? Please. I did, Your Honor, speak to him, and it was not me. I believe it was Attorney Wills. I don't know if she spoke to him, who said that he was entering a plea, but when I spoke to him, I was just prepared to argue for bond for him. So I am prepared if he's not going to accept the plea, which the plea offer I do have. I can express what the plea offer is, because I don't know how
That's not correct. I had Mr. Banks. I represented Mr. Banks. He wants to accept the plea. I never spoke with Mr. Moore.
Okay, because on the email, you responded to, I think it might have been like a mix-up. On the email, she asked if he was clean, you responded yes. So I thought you were speaking from Mr. Moore. But
Okay,
nonetheless-
let me do this, Ms. Moses Counts. Let me go ahead and hear from Ms. Duncan. And
Okay.
get I've heard that he doesn't have,
Mr. Banks, not Mr. Moore, but sorry, go ahead.
that we that he does not have much of a history. What happened in this case, Ms. Duncan?
In this case, Your Honor, it happened on April 8th, 2023. Officers responded to the Spring Hill Suites by Marriott at 3459 Buckhead Loop Northeast in Atlanta. When they arrived on scene, they spoke to the manager of that location, of Mr. Mark Mukwangu, and a worker, Mr. Wayne Wesley, who indicated that a person identified later as a defendant was sitting in the lobby of the location, and he had been previously told several times to not be in this location and leave. And when they told him to leave, they indicated that he threatened them. Officers walked over to the defendant, who was still seated in the lobby, and they identified themselves as the worker and the manager and the police. And they indicated to the defendant that he is not supposed to be there. And once officers ran his history, they were able to find that he does have a previous criminal trespass warning from this location, indicated March 22nd, 2023. He did not leave the property at that time, and then he was taken into custody, Your Honor. For these reasons, since the defendant is not going to be taking a plea, I think, and he has a previous criminal trespass warning from this location, the state's recommendation in this case will be a $1,500 surety and stay away from the Spring Hill Suites at the address located on the record. No further contact with the manager or the worker whose names were listed on the record. That's Mark, common spelling, Mukwangu, that's Mukangu, and Wayne Wesley. Wayne is Wayne, Wesley, Westle. No further contact with either one of them. Stay away from the location. No alcohol, drugs, and weapons. No further violations of Georgia law.
Okay, Ms. Moses Counts, it's going to be $1,000 signature bond through the jail, and stay away from the Spring Hill Suites, and no further contact with those employees, and no drugs, alcohol, weapons while out on bond. Mr. Moore, I'm going to let you out. I'm going to let you sign your own bond, but you're going to have to come back and address these issues at a later time. You're also going to have to stay away from those Spring Hill Suites, or you're going to be right back here where you are. You understand what I'm saying?
But I didn't threaten nobody.
Okay, all right. So I'm giving you a signature bond. Good luck to you, sir. Who do we have next?
Next, we have position 20, Mr. Paul Moulton.
Good afternoon, Mr. Moulton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducted by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 002166F with willful obstruction of a law enforcement officer. Is there a history?
Defendant has 18 cycles. Defendant has a First Offender Act 2011 that was sealed for possession of a Schedule III controlled substance. Defendant has a felony burglary conviction in 2011. He has a felony theft by receiving stolen property conviction in 2015. And it has a receipt, possession, or transport of firearm by convicted felon in 2015. Defendant has a aggravated assault conviction in 2015. Defendant has another receipt, possession, or transport of a firearm by convicted felon in 2017. Then defendant has probation violations in 2011, 2017, 2019, 2020. And nothing further, Your Honor.
Thank you. Ms. Duncan?
I would like to indicate for the record that this defendant does have two cases on today's calendar. He's position 19 and 20.
Okay, thank you. So position 19 is another willful obstruction of a law enforcement officer and a improper left turn and a failure to have license on person. And that's in case 23 CR 002165F. All right, you want to talk about the first one, position 19, Ms. Duncan?
Yes, Your Honor. In this case, the defendant did hinder Officer J. White and Sergeant M. White of South Fulton Police Department by fleeing from them when they on scene when they attempted to give him a citation because he was observed making a left turn in an area designated only for right turns in the area of Old National Highway near 6149. And when he was asked for his license, he didn't. He told the officers he did not have his license on person. He was operating a motor vehicle at that time with a Georgia temporary tag. This defendant does have an extensive driver's history report, and I believe does have an active suspension for a failure to appear with a violation date of November 6, 2022. The state does have concern about this defendant's risk of the offense, given the history as alleged in his driver's report. He has at least 9 citations in his history, well, actually 10. They include speeding, improper or erratic lane change, failure to maintain insurance, failure to appear, speeding, and other insurance and seatbelt violations. So given this defendant's driving history and the facts as alleged in this incident, the state is going to be requesting a $3,000 total surety. That's $1,000 surety per count. No further contact with either of these officers. However, we will defer to the court. We just want to make sure that there is no violent or hindering contact of any nature with these particular officers at any point in the future. No alcohol, drugs, and weapons, no further violations of Georgia law, and no driving unless he's validly licensed, insured, and registered. I did also see that this defendant is wanted out of McDonough for probation violation. Nothing further from the state.
Position 20.
So in this case, position 20, Your Honor, the defendant did obstruct a MARTA officer, Officer Husey of the MARTA Police Department, by pulling away from the officer and taking flight down the platform at the Lakewood MARTA station. He dropped off the platform down to the tracks and then ran out of sight of the officers. He had been asked to leave the train because he was drinking from an open bottle of Parmesan brandy. And while officers ran his name, he came back as wanted, so they were attempting to take him in custody. And at that time, he did flee. This incident did occur on February 7, 2023 at the Lakewood MARTA station, located at 2020 Lee Street in Atlanta. Again, Your Honor, we do have the concerns about the risk of reoffense in this case. This is 2 instances of willful obstruction of officers attempting to flee and offenses of that nature. So we do have some concern about his likelihood to respond positively to the legal process, because this defendant continues to commit offenses, and when he is apprehended, to take accountability for those, he continues to try to flee from persecution. So for that reason, Your Honor, in this second case, the state is going to be requesting a $1,500 total surety. No further contact with the officer in that case, and stay away from the Lakewood MARTA station at the address already indicated on the record. No alcohol, drugs, and weapons, and no further violations of Georgia law.
Ms. Moses counts.
Thank you, Your Honor. Mr. Mooten is 31 years old. He does have a good address here in Decatur, Georgia. He does have a 2-year-old child that is his child that he does provide primary care for. However, he currently is looking for employment. He recently had employment, but now he's looking back for employment. And so based on that, he would not have the means to pay a high monetary bond. He does have significant ties, however, to Georgia. He's been present here for the last 15 years. And so based on that, I would ask for your consideration of low of a bond as possible. Nothing further.
In position number 19, for the willful obstruction, a $500 good bond. For the improper left turn, a $250 good bond. For the failure to have license on person, a $250 good bond, making for a total of a $1,000 good bond on that case. Position number 20, a $500 good bond. Abide by any active MARTA suspensions, and for both cases, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Moulton.
Thank you, Judge.
So just to be sure, Your Honor, you said 500 good and then 250 good on the first case?
That's correct.
In the second case, 500.
Yes. Good.
Thank you.
Okay.
We ready for courtroom 3, Your Honor?
Okay. And who do we have? Courtroom 3, are you ready to go?
I'm sorry, no, I'm not ready. One moment, please. You can go back to courtroom 2. Thank you.
Okay, who do we have?
Petition 21, Daniel Navarro.
Good afternoon, Mr. Navarro. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Navarro, you've been charged in case 23 CR 002177G with battery, family violence, and cruelty to children in the 3rd degree. Is there a history?
Defendant appears to have 2 cycles, and defendant has 1 cycle out of Georgia. This appears to be the defendant's first cycle out of Georgia. Defendant has 1 cycle out of Texas, but no convictions. Nothing further, Your Honor.
Thank you. Ms. Duncan?
Yes, Your Honor. In this case, it did occur on April 9th, 2023 at about 2:31 in the morning. It did occur at 3329 Old Milton Parkway in Alpharetta. In this case, the defendant and the victim in this case, who is Andrea Falcone, that's ANDREA FALCONE, and a minor with the initials of AN. The defendant and the victim, who are married, were in a verbal dispute that turned physical after the defendant and the victim were arguing regarding alcohol. And the defendant got upset and placed his hands on his wife. She stated to officers once they arrived that he pinned her against the wall and slammed her head into the wall. She further explained to officers that she was concerned about their children, and that their daughter, the minor with the initials AN, was present during this incident. The victim indicated that she did have a bump on the back of her head. Officers, given that there were 2 versions of events, of course, the defendant in this case says that the victim did in fact come at him with a weapon, but she stated that that was in defense of her and her daughter. So when they got the conflicting accounts of the details, they asked if they could speak to the minor, who I believe is 10 years old, and they gave permission at that time to speak to her. She told officers that she indicated that the defendant did attack her mother, and she further explained to officers that he did grab her mother. Her mother did grab his shoulder, but the defendant did in fact pin Miss Falcone against the wall and slam her on the ground. And as a result of this attack, the victim did sustain visible bruises and marks on her back, left elbow, and head, as indicated by officers. In this case, we do have some concern about the risk of reoffense. These parties are married and they do live at the location. This incident did concern alcohol, so we do have some concerns that in the future, if these types of situations occur, violence may occur between these parties. It did just happen yesterday at about 2:31 a.m. So we do not believe that there's been an adequate cooling off period. The parties are married, so we do believe that there may be some risk of intimidation in this case. So we are requesting in this case for a total $4,000 surety. That's $3,000 on the battery, family violence, and $1,000 on the cruelty to children in the 3rd degree. No further contact with either victim, but I want to be clear that that does not include any obligations for support that may be in place. 3rd-party contact for other children if they are a part of the family. Stay away from the incident location, 1-day anger awareness, no alcohol, drugs, and weapons. In this case, Your Honor, 1 second, I'm gonna look at I'm checking my notes to see if we were able to speak to this victim. Either way, Your Honor, I would like to sound for her just in case she is here. I would like the court to sound for her when appropriate. We were not able to make contact with Ms. Falcone or the minor in this case. So for those reasons, Your Honor, we would ask that the court grant our recommendation of no further contact and stay away. But just in case she is here, we would like the court to sound for her.
Ms. Falcone, if you are with us this afternoon, now is your opportunity to speak if you choose to do so. Does not appear so, Ms. Duncan. Ms. Kim?
Yes, Your Honor, Ms. Navarro. He is actually 38 years old, Your Honor, becoming 39, and he's from California. He was born there, and he actually resided in Florida until 1.5 months ago. He got a job as an architect at a really, really good firm here in Georgia, and he is in the transition to move to Georgia from Florida permanently. He has no objection to stay away from that incident location, which was a hotel where they were temporarily staying until they find a permanent place. He will have his own different room or hotel, and he has no objection to not to have any contact with Andrea Falcone, who probably still intoxicated. Your Honor, my client denies the allegation, and sometimes minors can be, if somebody asks you and she just kind of nodded, and it was just kind of like, it could be more influential to a minor when she has to choose between mom and dad. That's a really, really difficult situation for any minor to be in. Your Honor, we would like to request for a signature on bond, and no further contact is fine. Thank you.
All right. So for the batter, it's going to be a $2,000 signature bond through pretrial per the judge. For the cruelty, $1,000 signature bond through pretrial per the judge. Makes it a total of a $3,000 signature through pretrial. 1-day anger awareness. No further contact with Ms. Falcone. Stay away from the Old Milton Parkway address. If he needs to go back to that address to retrieve any belongings, he can do so. One-time law enforcement escort will be required. Third-party transfer of any minor children for visitation, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, the state would just like to place its objection to the signature and the battery family violence with alleged injuries on the record.
So placed. Who do we have next? Good luck to you, sir.
Next, we have position 22, Gabriel Parks.
It was my understanding that Mr. Parks was not able to be interviewed. Is that right?
No, Your Honor, I was able
Oh.
to get with him during the calendars. I'm
Okay,
prepared.
okay, thank you. Good afternoon, Mr. Parks. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 002167B with criminal trespass and possession and use of drug-related objects. Is there a history, Ms. Boxley Chester?
Yes, Your Honor. Defendant has 27 cycles. Defendant has a forgery first degree that was in 2003, and a probation violation in 2005, a failure to appear in 2006, a failure to appear in 2013. He had a probation violation in 2015. He had a entering auto or other motor vehicle with intent to commit felony. That was in 2017, and he has a probation violation in 2017, 2018, 2019, and then he has an aggravated assault conviction in 2020. And nothing further, Your Honor.
Ms. Duncan?
Yes, Your Honor, I would like to indicate for the court as well that this defendant does have an additional open case. It is a bind over case. It will be accused after court today, given the volume of cases that we had. It's a criminal trespass and possession of drug related objects also from April 4th, 2023. In this case, it occurred on March 28th, 2023. And the defendant returned to a racetrack gas station and began located at 1180 Virginia Avenue in Hateville, and began cursing and causing a disturbance with other patrons inside of this location. This defendant had been previously trespassed from this location, and that trespass has been active since August 21st, 2022. Incident to arrest officers did search the defendant in this case, and they did find a glass ball with a glass pipe attached to it, which they believe to be the type of glass pipe that can be used to inhale crack cocaine. For these reasons, Your Honor, we do believe that there is a risk of reoffense in this case. There's this case, and then he had the open bind over case of the same and similar charges. So we do have some concerns about the risk of reoffense here and the likelihood to respond to the legal process. He does have a lengthy criminal history with at least 2 of these types of offenses currently. So for those reasons, Your Honor, there is a preset bond on the $1,000 on the criminal trespass. However, we've added the possession of drug-related objects. So the state's recommendation is going to be a $2,000 total surety bond. That's $1,000 per count. Stay away from the racetrack gas station located at 1180 Virginia Avenue in Hapeville. No alcohol, drugs, weapons, and no further violations of Georgia law.
Yes, thank you, Your Honor. Mr. Parks is 42 years old. He does have a good address here in Atlanta. Your Honor, he is not employed currently. He would not have the income to pay a monetary bond. However, I do believe that he is not a flight risk. He's born and raised here, so he does have significant ties to the state. These are nonviolent offenses, Your Honor. I would ask, based on that, for your consideration of signature bonds on both offenses. Nothing further. Thank you.
Given his history, I'm reticent to give him a signature bond, but it'll be a $250 good bond on each charge, making for a total of a $500 good bond. Stay away from the racetrack on Virginia Avenue with no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Parks.
Position 34 is next, please. Oh, well, that were the big ones. Yeah.
And this is Tiffany Harper. Yes, good afternoon, Ms. Harper. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Ms. Harper, you've been charged in case 23 CR 002160E with obstruction of a law, willful obstruction of a law enforcement officer, 2 counts and 1 count of battery. Is there a history?
No, it's supposed to be simple battery.
Okay, hold on.
Miss Harper, if you could remain silent, I'm your attorney and I want to protect your rights. So if you could just remain silent for me, that would be awesome.
Thank you. Ms. Boxley Chester, is there a history?
Defendant has 5 cycles. Defendant doesn't appear to have any felony convictions. Nothing further, Your Honor.
Okay, so I'm showing something a little different. So if Miss Boxley Chester can take a look, I'm showing she has 60 plus cycles out of South Carolina. So let me take a moment to look at Miss Harper's history and make sure I have the right individual in her history. Because we're actually showing quite a few arrests. Okay. Yep, Tiffany Yvette Harper, and date of birth 12/25/1980. So yeah, date of birth and name matches up with the South Carolina history.
Yes, you are correct. This is Faulkner, right?
Okay.
My apologies.
Oh, no, it's fine. I just wanted to make sure I wasn't about to say she has 68 cycles on her history. She didn't. So Your Honor, we are showing 68 cycles out of South Carolina. Her most recent was a case from November of 2021, which was dismissed, but it was an assault and battery in the 3rd degree. She had some shoplifting charges, public disorderly from September of 2021. She had a violation of city ordinance from July of 2021. Let's see, failure to comply, May of 2021, resisting arrest, April of 2021. All of these are convictions, Your Honor. Let's see.
And I'm sorry, Deputy Falk, are these
Yes.
out of Georgia?
No, these are all out of South Carolina.
Okay.
And then she also has, let's see, I think it was 5 cycles. That is correct. 5 cycles out of Baltimore, Maryland. But the last cycle out of Maryland was an assault. It was dismissed and it was from 2009. So the bulk of her history, Your Honor, is out of South Carolina. I'm seeing several convictions for entering premises without notice. So essentially our version of criminal trespass, theft charges, hindering officer charges. She has quite an extensive history. I just went over the last about 10 cycles of her history. So this happened April 7th of 2023 at 30 Alabama Street. Officers observed 2 individuals arguing on the Peachtree side of 5 Points MARTA station. They saw the defendant walk away, and Mr. Charlie Watson Jr., who's the victim, stated the defendant slapped him in the face and he wished to press charges. This was also confirmed by multiple witnesses who the officers spoke to at the scene, as well as CCTV cameras that captured the event. Mr. Watson had a bruise to his face, as well as swelling, which is the reason the state did upgrade this charge from a simple battery to a battery, because the officers were able to observe bruising and swelling to the defendant's face, to the victim's face. They did approach the defendant, asked her to place her hands behind her back. She refused, tried to run, and began resisting the officers until they were able to finally place her in handcuffs, which is the basis for the 2 willful obstructions. As you've heard, Your Honor, this defendant has 68 cycles out of South Carolina, 5 cycles out of Maryland. We do have a serious concern that she is a flight risk due to her extensive history, as well as a risk of reoffense, and not likely to appear in court since the last case she had was 2021 out of South Carolina. I'm not sure what ties, if any, she has to Georgia. The state's recommendation for this reason is a $4,000 surety bond, $3,000 for the battery, $500 for each obstruction. Stay away from 30 Alabama Street MARTA station, little 5 points. No alcohol, drugs, or weapons, 1-day anger awareness, and no further contact with Charlie Watson. We did try to attempt to get in contact with Mr. Watson from the information we had in the warrant, but we're not able to get in contact with him. However, we are asking Your Honor sound for him.
If Mr. Watson is present and would like to address the court, now is your opportunity. Does not appear so, Ms. Falk. Ms. Moses counts. Welcome.
Yes, Your Honor. Ms. Harper is 42 years old. She is looking for housing. Currently, she's staying at the Salvation Army here in Atlanta. Your Honor, she's not currently employed. She would not be able to afford a monetary bond, especially as stated by Deputy Falk. And so I would ask for your consideration of a LOVA bond as possible. I understand that she has history in other states. However, she does have no history here. And based on my conversation with her, she felt threatened, and so that's what led to the physical alleged altercation on video, Your Honor. She has been present in the state for the past month, as she did move here from South Carolina in the hopes of getting stable housing and employment, and so I don't believe that she would be a flight risk based on my conversation with her. And so based on that, I would ask for your consideration of a LOVA bond as possible. Nothing further.
For each of the obstructions, it's going to be a $500 good bond. For the battery, it's going to be a $1,000 good bond, makes for a total of a $2,000 good bond. Stay away from 30 Alabama Street, no further contact with Mr. Watson, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
So, please. I have some questions, so please.
Ms. Moses, Ms. Moses Counts will, who's your lawyer, will speak with you after court today and answer any questions that you might have, okay?
Yes, sir, thank you.
You're welcome.
Your Honor, we'll like courtroom 3 to go again with Ms. Alexander, Rakita Alexander. She has family here in courtroom 2.
Did you get that, courtroom 3?
Courtroom 2, can you go, please? I have an issue back here. Thank you. One moment, Judge.
Okay.
Before you, Your Honor, is position 24, Mr. Alan Perry.
Good afternoon, Mr. Perry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're doing by video. Do you agree to have your case heard by video?
Good afternoon.
Is that a yes, Mr. Perry?
Yeah.
Okay, thank you, sir. You've been charged in case 23 CR 002170C with loitering and prowling. Is there a history, Ms. Duncan? I'm sorry, is there a history, Ms. Boxley Chester?
The defendant has 17 cycles. Defendant has a battery conviction in 2012, battery conviction in 2018, and a failure to appear in 2018. Defendant has cycles that are in 1985. I don't know if you want me to read those as well.
No, you're fine.
I have nothing further.
Okay. Ms. Duncan?
Yes, Your Honor. In addition, in 2017, this defendant did have a simple battery against a police officer arrest. However, that was not prosecuted. In this offense, it did occur on April 8th, 2023. Officers were dispatched to the location of 902 Margaret Place Northwest. Upon arrival, they noticed a suspect indicating wearing a specific type of clothing. They approached him and asked what he was doing in that area. He stated to officers that he was looking for vehicles for the right price. They had been called to that area on a suspicious person call. Upon further speaking, when they went to the incident location, they spoke with Ms. Shada Kirkland, that's CHADA Kirkland, KIRKLAND, who was able to identify the defendant as Mr. Perry. In this case, she indicated that she was inside of her home and she heard banging on her window, on her doors and windows. And she stated that she was afraid for her life. She did not know this particular person at all. She was able to get a description of him because he was banging on our window so she could see him. She indicated to officers that she doesn't know him. She's never seen him before. She said that she was frightened for her life and scared that he was going to come back and harm her because she was at home with her child. She was whispering in the phone apparently when she called 911. And because she did not want the defendant to know that she had called 911. This defendant was then detained. For these reasons, Your Honor, given this defendant's history, we do have some concerns about what was going on here. We were not able to make contact with Ms. Kirkland for those reasons, Your Honor. The state is going to be requesting a $2,000 total surety, no further contact with the victim in this case, stay away from the incident location of 902 Margaret Place Northwest, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Mrs. Counts.
Yes, thank you, Your Honor. Mr. Perry is 59 years old. He has an address here in Atlanta. Your Honor, he's not employed currently. He would not be able to afford to pay a monetary bond. He is on disability, and I do have some concerns about his health. He does suffer from seizures and diabetes, and from speaking with him, he has not been receiving his medication while in custody. And so I do have a concern about his declining health. He has significant ties to the state of Georgia. He was born and raised here. So I do not believe that he would be a flight risk. And so based on that, this is a nonviolent offense, Your Honor. And so I would ask for your consideration based on those things for a signature bond. Nothing further.
It's going to be a $3,000 signature bond through the jail. No further contact with Ms. Kirkland. Stay away from the Margaret Place address. No drugs, alcohol, weapons, bond. Good luck to you, Mr. Perry.
Thank you.
What was the bond amount, Your Honor? Because we did not hear you.
$3,000 signature through the jail.
Thank you. Next, we have, is courtroom 3 ready?
I'm ready to do Ms. Alexander. I'm sorry. Thank you.
And this is,
Number one.
good afternoon, Ms. Alexander. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Alexander, you've been charged in case 23 CR 002148H with battery family violence. Is there a history?
Yes, Your Honor. One moment. Defendant has 5 cycles out of Georgia. Defendant does not appear to have any convictions. Defendant has a failure to appear in 2011. And nothing further, Your Honor.
Ms. Falk?
Yes, Your Honor. This happened April 9th of 2023 at 2874 Fairburn Road Southwest at around 6 p.m. Miss Amiroa Abrams, and that is AHMIEROAH, Abrams, ABRAMS. Miss Abrams is 16 years of age. She reported to the police that her mother beat her with a stick. The defendant then confirmed that she in fact beat Miss Abrams with a stick because Miss Abrams was talking back and didn't want to clean the house. The officers were able to observe visible marks to the backs of Miss Abrams' thighs, which were seen by the police while Grady EMT was checking out Miss Abrams, who again, I say again, was 16 years of age when this happened yesterday. And so the defendant doesn't have any convictions. However, I would be remiss if I didn't point out to the court that she had a family violence battery in 2006 that was dismissed after she completed pretrial diversion. She then had a 2013 cruelty to children in the first degree, aggravated assault and battery, where she completed first offender, and then that case was dismissed. So Miss Alexander's had 2 bites at this apple, both charges involving family violence, and has now been arrested for beating her 16-year-old with a stick. The state has some real serious concerns here about this defendant's risk of reoffense. That family violence battery and that previous cruelty to children in the first degree are raising some serious red flags, as well as her method of discipline. I understand that children sometimes do need discipline if they are talking back, if they are behaving out of order, but beating them with a stick is not discipline, it's abuse. And for those reasons, we're asking for a $7,500 surety bond. She have no further contact with Miss Abrams, no alcohol, drugs, or weapons, and that she take a family violence intervention program course. Thank you.
Ms. Wells?
Thank you, Your Honor. My client is 40 years old. She is self-employed. She is a doula at Motherly Touch Doula Services, where she owns her own company and business. She has 8 children in the home currently. The child in question is her 17-year-old child. She states that child, there was a defects report made in regards to what happened. And actually my client made that report. So that child would not be returning to her home. She does not have any other income other than her self-employed business, and states she does not make that much money. And so in light of that, we will be requesting a signature bond. And she also adamantly denies the allegations as alleged by the state.
So Ms. Abrams has been removed from the home by defects. Is that what you're telling me, Ms. Wills?
Yes, and she said that she's previously filed or made reports for her child, unruly complaints. So.
Okay. So I'm going to have her abide by any defects orders, and she's not going to have any contact at this point in time. It's going to be a $5,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact at this time with Ms. Abrams, abide by any defects orders, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Ms. Alexander.
In your honor, the state doesn't usually do this, but we do object to that signature bond given this defendant's serious history involving the abuse of children.
Okay. So noted. Thank you, Ms. Falk. Who do we have next?
Next, we have position 26, Mr. Robinson.
Good afternoon, Mr. Robinson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Sir, good afternoon. How are you doing?
I'm doing fine, Mr. Robinson. Thank you. You have been charged in case 23 CR 0021788A with theft by shoplifting. Is there a history, Ms. Boxley Chester?
Yes, defendant has 12 cycles. Defendant has a First Offenders Act that was sealed in 2017 for burglary. Defendant has a armed robbery conviction in 2015. Defendant has an aggravated assault conviction in 2015. Defendant has a possession of firearms or knife during commission of or attempt to commit certain felonies in 2015. Defendant has a probation violation in 2013. That and defendant has another probation violation in 2022. And nothing further, Your Honor.
Okay, Ms. Duncan.
One moment.
And in Your Honor, while Ms. Duncan is addressing that, I will say we did receive from the DA's office and they accepted a transfer of this case so that it can be placed on felony first appearance tomorrow morning. The defendant has a co-defendant by the name of, just a moment, Your Honor. This defendant has a co-defendant by the name of Morrison, Kawan Morrison. And Mr. Morrison's case number is 20, it's the 23 CP number. They were alleged to have committed the theft by shoplifting in conjunction with one another. And then when they were arrested, Mr. Morrison also had drugs on his person. So when I reached out to the DA's office and noted that this case should be kept together because they were charged with the same offenses, obviously, Mr. Robinson was not charged with the drug offense. The DA's office agreed. If Your Honor would accept that, I can send over the transfer order now for Your Honor's signature so that this can be handled at felony first appearance.
Is there going to be some issue if I don't do the bond today?
It is not an issue until 10 o'clock tomorrow night. Well, no, let me see. Actually, let me take that back. I think it's until 3 o'clock tomorrow afternoon. However, first appearance is at 11 a.m.
Okay, so you like this to be placed on tomorrow's first appearance calendar for felony?
Yes, Your Honor, so that these cases can be addressed by the felony division. They have, again, Executive Director Hutcherson did accept this case and ask for the transfer.
Okay, Ms. McLeod, this is your case?
It is, Your Honor.
Yes, good afternoon. I'm going to have the DA's office, so Superior Court handle both of these cases. Okay?
Yes, Your Honor.
All right, so Mr. Robinson, we will see you back, well, someone will see you back tomorrow.
I want to state that my co-defendant.
Hold on, Mr. Robinson. I don't want you to get yourself in trouble or get your co-defendant. So you have a right to remain silent. Okay, let Ms. McLeod represent you, and whatever you need to tell the court tomorrow, you can have Ms. McLeod do that on your behalf. Okay.
Obviously, you saying tomorrow. I'm trying to tell you that my co-defendant assumed responsibility for the stuff that was caught on his person. That's why I wasn't charged with it. Why I gotta wait till tomorrow?
I understand, sir, but your case has been upgraded to a felony. So
how? I'm being charged.
You'll be able to speak with Ms. McLeod. Okay, she will explain it. So they'll see you back tomorrow.
Position 16.
And this is Ms. Hill?
Yes, correct.
Okay. Good afternoon, Ms. Hill. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 23 CR 0021559D with battery, substantial physical harm, and disrupting a public school. Is there a history, Ms. Boxley Chester?
Yes, Your Honor. The defendant has 4 cycles. She has 2 misdemeanor reckless conduct convictions in 2017 and nothing further, Your Honor.
I'm sorry, you said how many cycles?
She has 4. Yes.
Because her mic went out, so I couldn't hear.
Yes, 4 cycles.
Ms. Falk?
Yes, Your Honor. I just want to point out before we get started on this case that Miss Hill is, at the time of this incident, was 25 years of age. So this incident happened at 2400 Union Road, which is Westlake High School. The defendant went to Westlake High School along with 2 other individuals and got into a fight with a student. And the student's name was Miss Wykia Dawson, WY''KIA, Dawson, common spelling. They went to Westlake High School in order to fight her and did get into a fight with her, which caused staff members to then call for backup from other staff members inside the school. This also caused the teachers and the staff doing school functions to be disrupted. The staff had to leave their dismissal post, as well as the parking lot became overly congested during dismissal, which held up the clearing of the lots. Again, as I pointed out, this defendant was 25 years of age and frankly was not a student at that school and had no business going to that school, especially not to fight a person who is a student at that school. The state's recommendation on this case is a $5,000 surety bond, and that's going to be $4,000 for the battery. And I neglected to say the injuries to Miss Wykia Dawson was that she suffered bruising and swelling around her face because she was struck by this defendant multiple times with a closed fist. We are also asking for a $1,000 surety bond for the disrupting a public school. No alcohol, drugs, or weapons. Stay away completely from 2400 Union Road, which is the Westlake High School, and no further contact with Miss Wykia Dawson. Nothing further from the state.
Ms. Falk, why is this such a over a year old? Do we know?
Your Honor, I do not. I know that the warrants were taken out. It looks like on March 29th of 2022, but Miss Dawson, Miss Hill was not picked up until I believe it was yesterday. So I think although the warrants were taken out, she just wasn't located until they came across her and placed her under arrest for these charges.
Okay, thank you. Ms. Moses Counts?
Yes, Your Honor. Ms. Hill is 25 years old, Your Honor, and is does have good housing here in Atlanta. She does have a good address. She does have a one child, which is 5 years old, that does reside in a home with her that she provides primary care for. She does have employment. She works at a juice bar. Based on her income, she would not qualify for the services of the public defender after today. Your Honor, this, as you stated, has been some length between when this allegedly occurred. And so based on that, I think it further proves she's not a flight risk. She's born and raised here, and so she does have significant ties here. I don't think that there's a risk of harm towards anyone involved in this case based on the length of time that has passed. So I would ask for your consideration of a signature bond based on those things.
Your Honor, I will also add she has a foreign hold out of Gwinnett.
And do you know what that hold is for, Ms. Falk?
I just looked in the jail system. I can't see, they didn't upload the actual hold, but it is showing in the jail system she has a Gwinnett hold.
Okay. I'm going to release her to that hold. It's going to be a $4,000 signature bond through the jail on the battery, a $1,000 signature bond on the jail through the jail for the disrupting a public school. So it's a $5,000 signature bond through the jail. Stay away from Westlake High School. No further contact with Ms. Dawson. and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Hill.
And Your Honor, can it be placed on the order that she should be released to the hold only?
That's fine with me. Yes, she's to be released to that hold. And tell me again, Ms. Falk, I'm sorry, the hold is out of?
Gwinnett County.
Okay, Gwinnett.
Your Honor, okay. I'm not understanding the relevance of that, or why that would be necessary.
And just to make sure she clears it up, and that's I had planned on her, if there's a hold, it's normally that she's only released to that hold, and that she goes and deals with whatever else that she has to deal with. And I think that would be the quickest, easiest way to get that done, especially since I'm giving her a signature bond through the jail, and the fact that it had been over a year that this warrant had been out. So it might be in your client's best interest to go and just clear it up. So, okay. All right. Good luck to you, ma'am.
Next, we have position 29, Mr. Stroud.
Good afternoon, Mr. Stroud. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Stroud, you've been charged in case 23 CR 0022171E with theft of lost or mislaid property. Is there a history?
The defendant appears to just have one cycle out of Georgia, and that was a misdemeanor, NOLO, driving while license suspended or revoked. Nothing further, Your Honor.
Ms. Duncan?
Yes, and my apologies to the court for earlier. Apparently, they're testing the alarms.
Okay, you're fine.
This offense occurred at 1000 Johnson Ferry Road. This defendant took the victim in this case, Alexis Smith's wallet that she mislaid on the garbage can outside. He was seen on surveillance video footage of the going towards that garbage can, looking at the wallet, walking past it, coming back outside of that hospital location where I believe he's an employee as well. Coming back out, seeing that the wallet was still there, taking it into his own possession and going back in the building. It's indicated that they were able to track this defendant's movements through his key card access at the building. And apparently at no point did he come in contact with this particular victim to attempt to give that wallet back. The victim further stated that she did designate a coworker to try and go help her look for her wallet. However, this defendant was not the person. She had said that she wanted to go get her wallet, and at no point did he bring her wallet back to her. It's indicated that that was a Michael Kors wallet, that wallet did contain financial transaction cards, debit cards, store gift cards like Walmart and things of that nature. Your Honor, we are aware this defendant has limited history, but given the acts as alleged, he went past the wallet that he knew or likely knew was not his and went back and took it and did not return it. And in fact, apparently shortly after left the premises with it. We're going to be requesting a $1,500 surety and no further contact with Alexis Smith. We were not able to make contact with her. So we're going to be requesting that no further contact. I don't know if they work together, but I believe that they're both employees. So I don't know how this would work, and we'll defer to the court, but we would ask for a stay away from that location. No alcohol, drugs, weapons, no further violations of Georgia law, and a theft class.
Does he need to go back to the Johnson Ferry Road address?
He does, Your Honor. That's his place of employment.
Okay, and this Alexis Smith, is she employed there too?
I don't know anything about her, Your Honor, and my client doesn't know who she is.
I believe from the warrants here, and I believe she is also employed there.
Well, it's a bit late, so they don't have to encounter each other.
Right. I'm going to give him a $2,000 signature bond through the jail. He's not to have any contact with Miss Alexis Smith, and no drugs, alcohol, weapons while out on bond. I'm not going to keep him away from his place of employment. Is that okay with you, Ms. McLeod?
That is fine with me, Your Honor. Thank you.
All right. Good luck to you, Mr. Stroud.
Position number 5.
I'm sorry, say it again.
Position number 5.
I'm sorry, you're cutting off as
I'm
soon as you say the
Position
number.
5, Judge. Position number 5.
5, okay, this is Ms. Dean. Ms. Dean?
Yes, sir.
Okay, good afternoon, Ms. Dean. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that were conducted by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 002151A with battery family violence. Is there a history, Ms. Boxley Chester?
Defendant appears to have 2 cycles out of Georgia. Defendant does not have any convictions. Nothing further.
Ms. Falk?
Yes, Your Honor. We're also seeing an October 2021 simple assault DV 3rd out of Alabama. I just wanted Ms. Boxley Chester to check and see if you have that for pretrial as well.
Yes, give me one moment.
While Ms. Boxley Chester is doing that, this incident happened April 9th, 2023 at 2:15 a.m. at 3207 Sandalwood Drive in Sandy Springs. Sean Abbott reported that the defendant, his ex-girlfriend, came to the residence to grab a crock pot. Although they are Mr. Abbott and the defendant are on a lease, the defendant no longer resides at the residence, but they do share a 9-year-old son. The defendant then noticed Mr. Abbott with another female at the residence and struck him in the face with a closed fist, leaving a cut on his bottom left part of his lip. We did have an opportunity to speak with Mr. Abbott. He did state that they are not in a relationship. They do not live together, but they do share a child. He did confirm the events that happened in the warrant, stated this is not the first time this has happened, and that the defendant's name is on the lease of the incident location, but she is not currently living there and he is planning on getting her name taken off. He stated further that he only wants contact with the defendant because they share a child, but wants her to stay away from the residence. And he stated he would be here on Zoom, so we would ask that the court sound for Mr. Abbott. The state's recommendation on this, there is, again, as I said, we saw a simple assault DV 3rd out of Alabama in October 2021. We did not see a disposition on that. And our understanding from speaking with Mr. Abbott is that involved the father of one of her other children. So the state's recommendation on this, based on the risk of reoffense, is a $5,000 surety bond, no further contact with Sean Abbott. That's SHAWN ABBOTT. We are asking for third-party contact with the child. Third-party transfer of the child. Stay away from 3207 Sandalwood Drive, Sandy Springs. No alcohol, drugs, or weapons. 1-day anger awareness. Nothing further.
This is an opportunity to address the court if you choose to. You do not have to, but if you choose to, you're going to have to unmute yourself, activate your camera, and I'm going to have to swear you in. Okay, Mr. Abbott, if you'll raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. What would you like to tell the court?
Really nothing much further than what the prosecutor just stated. I don't mind having, continued contact with her. I just don't want her to come to, my residence anymore. That's really about it. Also, I really don't have a say-so in this, but do you think it would be possible that you could give her a signature bond? Because from what I'm being told by her boyfriend, he doesn't really have any money. And I mean, I'll do what I got to do to help her get out of jail due to us having a child together. And I'm currently working nights right now. But, I don't want to have to foot the whole bill for getting her out of jail when, I kind of put her in jail for a reason, of course. But that's really all I had to say.
Okay, you're not afraid of her?
I'm not afraid of her, but I do know her to be an unstable person.
Okay.
I feel like, if I did have to defend myself, I could. But the only thing I would say is, at this current moment, she does have a key to my apartment. And, you know, I wouldn't want her to come over here without me knowing, like, while I'm asleep or something like that. But other than that, you know, in a face-to-face situation, I'm not afraid of her.
All right, well, given what you're telling me, Mr. Abbott, I'm not gonna have her have any further contact with you. And I'm gonna
Okay.
I'm gonna have her stay away from your Sandalwood Drive address, okay? You're gonna
Okay.
have to go through a third party to arrange for visitation. Okay, so that means that, I mean, you all are not to have any contact whatsoever. So as your 9-year-old son is concerned, you're going to have a third party go through and transfer the child for visitation. Okay.
Okay. I mean, the only third party that we can use is her current boyfriend.
Well, however you all work it out, that's how you're going to have to work it out. But she's not going to be able to have any contact with you whatsoever. Okay.
Okay.
All right. Thank you, sir. I appreciate it. Ms. Wells.
Thank you, Your Honor. Ms. Dean is 32 years old, as it was stated. She does not have any prior convictions. She has 2 children, the 9-year-old who she shares with the alleged victim, as well as a 4-year-old. She is employed by Intuit QuickBooks, as well as will begin a job with Princess Cruises. She does not live with the alleged victim at this time. She states that she was defending herself. And this was a self-defense. She acted out of self-defense, and what led to the police being called. Both parties called law enforcement, and she stated that she called law enforcement to de-escalate the situation. As the alleged victim stated, and my client also shared with me that she's been in communication with him, and he stated that he was willing to pay the bond, and also said that he called the cops to retaliate against her for the prior incident that they had together. She had a TPO taken out against this alleged victim. And so there seems to be some sort of history. So in light of all of that, we're asking for a signature bond. If Your Honor is not so inclined, we'd ask for $8,000 bond.
It's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further contact with Mr. Abbott, stay away from the Sandalwood Drive address, third-party transfer of the minor child for visitation, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Dean.
Yeah, thank you.
You're welcome. Who do we have next?
Next, we have position 30, Stephen Weston.
Good afternoon, Mr. Weston. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, Your Honor. Yes, sir.
Thank you. Mr. Weston, you've been charged in case 23 CR 0021733Y with battery family violence. Is there a history, Ms. Boxley Chester?
I do not have that history, Judge.
Okay. Do you know if there's a history, Ms. Duncan?
One moment, Your Honor, I can pull that up. I'm having a bit of a technical difficulty. Just give me 1 second. This is Weston, correct?
Yes, position number 30.
Okay, what I have under this GCIC, this defendant does have cycles out of Carolina going back to 2008. It's 2 cycles. Well, no, I'm sorry, it's not 2 cycles. It is 16 cycles, with the last being in 2020. That was a guilty verdict by trial for resisting public officer. And there was a failure to appear as well in 2020 for out of Cherokee County in North Carolina for assault on a female. In addition to that, Your Honor, the defendant also has, in relation to Georgia, I'm sorry, he has additional history out of Tennessee from 2014 for public intoxication. There was a conviction in 2014. And further, there is 4 cycles out of Georgia. This defendant does have a conviction for possession of cocaine with intent to distribute from 2020, a probation violation in 2020, a driving without a valid license arrest out of Union County Probate Court with no disposition as listed, and in this case, Your Honor, which did occur on April 7th, 2023. Officer Nixon responded to an assault call at 24312 Plantation Drive Northeast. Upon arrival, he met with the victim in this case, who is identified as Militia Thongile, that is spelled Malisha, last name Thonginnially. She indicated to officers at the time that she was trying to use the bathroom when her significant other, the defendant in this case, Mr. Weston, got physical with her. She stated to officers that he told her to come lay down, but instead of doing so, she went to get up to use the bathroom instead. She stated that he came into the bathroom behind her and upset and proceeded to pick her up and drag her out of the bathroom. This caused her to have scratches on her left arm and the back of her neck. She also stated that she was screaming for help while he was dragging her. He was still on scene when officers arrived, and he denied having done these things to the victim in this case. Further, we were able to speak with her earlier today through our victim witness advocate, and she indicated that they've been together for 2 months and they both reside at that incident location and that his name is on the lease. She stated that they don't have a domestic violence history, and she indicated that she wasn't afraid of him. However, it is indicated that they were drinking during this incident, and further, he dragged her, grabbed her and pulled her out of that bathroom while she did not have her clothes on. She stated that they were fighting, and she recanted her story, saying that she did not, in fact, remember what was happening or who called the police. And she indicated that all of her belongings are there, and she had to go to a neighbor because he would not let her back in, and she had nowhere to go. So for those reasons, Your Honor, we have some concerns about the risk of reoffense, potential intimidation of this particular witness, given their relationship status, and the change in tone given her responses to the police officers at the time of the incident. And upon speaking to her today, we do have those intimidation concerns. This defendant does have prior instances with domestic violence out of other jurisdictions. So that does give us cause for the risk of reoffense as well. For those reasons, Your Honor, we're going to be requesting a $4,000 total surety in this case. No further contact with the victim whose name has been stated on the record. Stay away from the incident location, 1-day anger awareness, alcohol, drugs, and weapons, and no further violations of Georgia law. I do believe that the victim is on the line, and the state would like the court to sound for her when appropriate.
Ms. Militia, if you are on the line and would like to address the court, now is your opportunity to do so. You, of course, do not have to address the court, but if you would like to speak, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the quick truth? Can you hear me, ma'am? I can't hear you, ma'am. Can you hear me? Okay, it seems like there's something wrong with your audio. You may need to log out and log back in so that and choose the join with audio portion. Okay, we can't hear you, Miss Militia. Ms. Kim?
Yes, Your Honor. Mr. Weston says he's been here in Georgia for 2 years. He was born in North Carolina, and then he moved here with his wife. And he's married, Your Honor, and he is full-time psychology student for master's degree, Your Honor. He also served in the military, so he's a veteran, and his wife made a sacrifice for him to pursue the master's degree, Your Honor. He says he does not know Melissa, who she is exactly. So we would like to, he denies the allegation as well. We would like to request for signature on bond since he is a full-time student, does not make a lot of money at this point. So signature bond would be great, Your Honor. Thank you.
Okay, so I'm just confused. He doesn't know Miss?
That's what I was told.
Okay.
I just want to say for the record, he was on scene when the officers arrived, and he denied that he had done anything to her. So.
Well, I mean, you've got him charged with battery family violence. Is there, how's the family violence come into play?
Yeah, it's indicated to us by the victim that they both live at that location and have been doing so for 2 months.
Okay, let's see, Miss Militia, are you?
While we are waiting for Miss Militia, Mr. Weston, did I understand correctly about you knowing?
Me and my wife, Rosa Alvarez, live there. Me and my wife, Rosa Alvarez, we're on the lease. I'm on the lease, and my wife, Rosa Alvarez, is on the lease. I only know Militia through a common friend, a boyfriend of hers that's now locked up in Union County. They have him in Union County locked up for something, but that's how I met her in the previous relationship with her boyfriend. And, you know, she started coming down to visit us. My wife just actually left. That is my residence, the 24312. She has nothing to do with that residence. Me and my wife, Rosa, are primaries on that lease, and that's my physical address in Atlanta, Georgia, man. But I just know her through a boyfriend, or her boyfriend, G, and that's how I met her originally. And she was coming down after work and just coming to hang out. And, that's what I
Mr. Weston, you do not have to discuss any facts of the case because you're innocent, and I want you to stay silent.
And then just again, to be clear, Your Honor, she did indicate to us, since I don't know if her audio is working, that they've been living there and they are together, and they have been for those 2 months.
All right, so do we have Ms. Militia? I don't know if your audio is working or not. It appears that it's not. So given what I do know, as far as the Plantation Drive, there's going to be no further contact with the alleged victim. And you can go back to Plantation Drive on one occasion with law enforcement to retrieve any. It's either if she is still there, you cannot necessarily be there. If she is not there, then then you can reside there. But since you're not to have no further contact with her, and I'm not sure what the living situation is, then if she's there, you cannot be there. If she's not there, then you can stay there. It's gonna, and I'll give her one additional chance. Miss Militia, are you able to address us? Okay, it doesn't appear that that you have audio, ma'am. It's going to be $1,000 good bond, no further contact with the alleged victim. Stay away. You can go back to the Plantation Drive address on one occasion with law enforcement. On that occasion, if Ms. Militia is there, then you cannot be there. If she's not there, then you can reside there. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. West. Who do we have next?
Position 10, courtroom 3, Your Honor.
And Ms. Kim, it looks like you're going to need to speak with him after court today. It appears that he's confused as to the court's ruling. Okay.
Yes, Your Honor.
All right.
In Your Honor, Lashea Flanagan, there is a cross defendant on this calendar by the name of Amina, and I apologize for my pronunciation, Salahuddin, which is position 27. The facts on the two cases are the exact same.
Okay. And is Miss Salahuddin in courtroom 3?
Yes, Your Honor.
Okay,
They're both
so-
in courtroom 3.
Okay, so we'll take her next.
Thank you, Your Honor.
All right, thank you. Good afternoon, Ms. Flanagan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yes, sir.
Thank you. You are charged in case 23 CR 002162F with battery family violence. Is there a history? Ms. Boxley Chester?
The defendant has a total of 4 cycles. Does not appear to have any convictions.
Okay.
And actually,
okay. Yes, Ms. Fall.
Actually, Your Honor, she is under a first offender conviction where she is currently serving 5 years on probation for an aggravated assault charge that she pled guilty to September 30th of 2022. I can pull the case number for Your Honor. My Odyssey is giving me fits right now. But the facts of this case, Your Honor, are as follows. The defendant was at the residence located at 3545 Charles Drive in East Point. She stated she got into a physical altercation with her daughter, 18-year-old Amina Salahuddin, over an EBT card. The defendant stated that Ms. Salahuddin asked to use her debit card and the defendant asked for $50. And Ms. Salahuddin asked for $50. Defendant stated that Ms. Salahuddin disagreed, and according to the defendant, she stated that Ms. Salahuddin struck her. According to Ms. Salahuddin, she stated the defendant got upset when she refused to give her $50 to use her EBT debit card, and then the defendant struck her. Ms. Salahuddin did have a laceration to the right side of her face that the officers could observe. The defendant is under, as I said, that aggravated assault conviction where the defendant is currently serving a 5-year probation sentence from September 30th of 2022 in Fulton County. She was also ordered to do 8 weeks of anger management, parenting classes, and no further contact with Shaquana Flanagan, who I believe, based on the name as well as the charge of it, aggravated assault family violence, is related to her. The state is asking, based on that current open probation for aggravated assault and then this offense, we are concerned about a risk of reoffense as well as her potential to harm those closest to her. We are requesting a $7,500 surety bond, stay away from 3545 Charles Drive, East Point, no further contact with Amina Salahuddin. We are asking for family violence intervention program. She is currently scheduled to do 8 weeks of anger management, but I'm not sure if she has actually completed the terms and conditions of that part of her probation as of yet. Nothing further from the state.
Ms. McLeod?
Yes, Your Honor. My client is 39 years old. She is the mother of 3 adult children, and she also has a 3-year-old. She tells me that she's pretty anxious to get out of jail because her 3-year-old is currently staying with her godmother, who is in her 70s, and she's really concerned because she does not think that that is the best option for her child. She denies his allegations, Your Honor. This is her daughter. And she says her daughter became very upset with her because she would not allow her to use her card. And her daughter was the one who struck her, Your Honor. She did not, she was not the one who started this. Her daughter struck her, and she was really just defending herself. My client does not have a significant history, Your Honor. She did tell me that she was on probation for this charge. She has completed the anger management course, she tells me, Your Honor, and she has not done anything that would be violative of her probation because she was attacked here. I would ask the court to give my client a signature bond so she can get out of jail to take care of her 3-year-old minor child. Nothing further, Your Honor.
And Your Honor, I do have that case number. It's 21 SC 179945. And the victim in that case was again her child, her other child, Shaquana Flanagan.
Who lives at the Charles Drive address?
My client lives there.
Does Miss Salahuddin live there?
No, Your Honor.
Okay.
And I would appreciate if we could verify that with her defense attorney as well, just to clarify, because I don't have information either way.
Who's representing Miss Salahuddin? Miss Kim, are you representing Miss Salahuddin?
Yes, I do, Your Honor.
Okay. Can I get Ms. Boxley Chester, Ms. Salahuddin's history, if there is one? Position 27.
Defendant has 2 arrest cycles. Defendant has a misdemeanor willful obstruction of law enforcement officers in 2022, and nothing further, Your Honor.
Okay. And Ms. Kim, does Ms. Salahuddin live at the Charles Drive address?
Actually, she did, but she's gonna go and stay with her auntie, who will be a co-signer for her. Her name is Gente Robinson, and I was able to speak to her. Her auntie will be co-signing for her to get out. She is 18 years old. She completed 11th grade, and she wants to get GED, and she does not have a job, Your Honor. She's still kind of like a student in a sense. Transitioning student. Jantay Robinson spells with Jantay, just in case.
Okay.
And Your Honor, just to put it on the record, based on Ms. Salahuddin's lack of any history, as well as our belief that under 17-4-20, that it is Ms. Flanagan who's the predominant aggressor, the state is recommending a $4,000 signature bond through pretrial services with Ms. Salahuddin, no further contact with Lashaya Flanagan, no alcohol, drugs, or weapons, and we are also asking for 1-day anger management through pretrial.
So for Ms. Flanagan, it's going to be a $5,000 signature bond through pretrial per the judge, 1-day anger awareness, no further contact with Ms. Salahuddin at the present time, no drugs, alcohol, or weapons while out on bond. All right, good luck to Ms. Flanagan. May I see Ms. Salahuddin next, please? Good afternoon, Ms. Salahuddin. Again, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Was that a yes?
Yes,
Thank
sir.
you. You have been charged in case 23 CR 0022161F with simple battery family violence. As we've already had a conversation regarding your case, your bond is going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further contact with Ms. Flanagan, stay away from the Charles Drive address, and no drugs, alcohol, or weapons while out on bond. If you need to go back to that Charles Drive address, you can go back there on one occasion with law enforcement to retrieve any belongings that you might have there. Okay? All right. Good luck to you, Ms. Salahuddin and Ms. Flanagan.
And Your Honor, given the fact that these defendants have vastly different histories, including the fact that Ms. Flanagan is on probation currently for family violence, aggravated assault against one of her other children, the state does object to a signature bond.
Okay, thank you. Who do we have next?
Position 31, Mr. Larry Williams.
Yes, good afternoon. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we're conducting by video, Mr. Williams. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Williams, you've been charged in case 23 CR 002175G with theft by taking. Is there a history, Ms. Boxley Chester?
Defendant has 30 cycles. Defendant has a burglary conviction in 2008, a criminal attempt to commit a felony in 2009, possession of tools for commission of a crime in 2009, a burglary in 2012, criminal damage to property 2012. Defendant has 5 failure to appears in 2013 and a misdemeanor criminal trespass in 2019. Nothing further, Your Honor.
Okay, Ms. Duncan.
Yes, Your Honor. This incident did occur on April 7th, 2023. Officers responded in reference to a theft call at 2200 Godby Road, apartment I-4. Upon getting to that location, they spoke with the victim in this case, and Miss Tamila Gordon. That's Timalia, last name Gordon, Gordon. It's indicated that she stated to officers that the defendant had taken a package that was delivered to her apartment around 7 a.m. She stated to officers that moments after the defendant had done so, she observed him take the package from her doorstep, and around noon, when her husband was putting things inside of the car heading to work, they noticed that the defendant, who was later identified, was still standing around in that area. And she told her husband who he was, and then her husband approached him and asked why he had taken the package. He indicated that he denied attempting to take it. However, when officers arrived and made contact with the defendant and asked him why he took the package and what happened, he stated to officers he took the Amazon package from the front step, went to the corner store and sold it to a kid for $10, went and got some crack rock and smoked it, and that he just broke the pipe on the ground. He was sitting down, so at that time, officers took him into custody, given the statements that he had made. He was placed in the back of the patrol vehicle. There was video surveillance footage provided by Ms. Gordon from her phone, and she saved it and provided that to officers that did, in fact, show the defendant in this case walk up to her front porch and take the package and conceal it in his bag and walk off. For those reasons, Your Honor, given the fact that this defendant has a significant history of burglary and one prior theft by taking conviction from case 19 SC 170634, the state is going to be requesting a $2,500 total surety, no further contact with the victim in this case, and stay away from the incident location as previously stated on the record. No alcohol, drugs, weapons, no further violations of Georgia law, and a theft class.
Ms. Kim?
Mr. Williams is 68 years old, Your Honor, and he is residentially challenged. He does not have any phone. And I actually emailed out to social workers so that way they can have a visit and provide housing resources. We do have his brother's phone number to be able to contact him. And we would like to request for a signature on bond. And he has actually a hold at Muskogee County, Foreign County for failure to appear, so he has to be released to that place anyway, Your Honor.
All right, it's gonna be a good bond. No further contact with Ms. Gordon. Stay away from the Godby Road address. No drugs, alcohol, weapons while out on bond. And Ms. Kim, if you'll have a social worker go by for housing concerns out. And if I see him on the SAP calendar on April 25th, we can readdress it at that time if need be.
I'm sorry, Your Honor, could you restate your ruling? It was going in and out.
$1,000 good bond.
Thank
No
you.
further contact, stay away, social worker visit, drugs, alcohol, weapons. Okay,
Yes.
who do we have next?
Position 32, courtroom 3.
Good afternoon, Ms. Amundio. I am Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. You've been charged in case 23 CR 002176A with battery. Is there a history?
Defendant has one cycle and no conviction, Your Honor. Nothing further.
Thank you. Ms. Duncan?
Yes, Your Honor, in this case, it did occur at 5909 Glen Ridge Drive on April 9th, 2023. The victim in this case is Melissa Chavez. That's MELISSA Chavez, CHAVES. It's indicated that on this incident date, the defendant in this case called Ms. Chavez over to that location and began ganging up on her with multiple unknown females. They struck her multiple times in the face, causing visible injury to her nose that officers notated. She was able to identify this particular defendant from the group of people that attacked her because she noticed her coming out of the bathroom and yelling at her. We do have some concerns about the risk of reoffense given the nature of this attack. From what we know, it seems to be random and violent in nature with visible injuries alleged. So for those reasons, Your Honor, the state is going to be requesting a $3,000 total surety. No further contact with Ms. Chavez. Still, well, we don't know whose address that is, so we would defer to the court on the stay away. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. I'm not sure if Ms. Chavez is on the line, but we would like the court to sound for her just in case.
Ms. Chavez, if you are on call and would like to address the court, now is your opportunity to do so. Does not appear so, Ms. Duncan. Ms. Kim?
Yes, Your Honor. My client
is there someone that's trying to come in under MARV?
Okay. My client is 19 years old, Your Honor. Actually, she is gainfully employed at Daily Publix. She graduated from high school. She was born and raised here in Georgia. Your Honor, she does not reside at 5909 Glen Ridge Drive. She has a completely different address. And again, the warrant says there were other females who ganged up on complaining witness Chavez. There's nothing that indicates that my client was the very one who actually had hit the alleged victim in this case, Your Honor. So we would like to ask for a signature on bond. She has no history whatsoever, and that's it, Your Honor.
And just to be clear, the victim did indicate in the warrant that there were several people. However, one of those people was the defendant in this case, and she noticed who she was. I'm guessing because she knew her and she was able to identify her because she actually came out of the bathroom and she was able to see her face before the attack started.
My client denies the allegation, Your Honor.
It's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness. Stay away from the Glen Ridge Drive address. No further contact with Ms. Chavez, and no drugs, alcohol, weapons while out on bond. Good luck to you, ma'am.
Position.
Thank you.
Position 33, Mr. Zeno.
Good afternoon, Mr. Zeno. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
So more to be, yes, Judge.
Thank you. You have been charged in case 23 CR 002180G with battery family violence. Is there a history, Ms. Boxley Chester?
This appears to be the defendant's first arrest, Your Honor.
Okay, Ms. Duncan.
Sorry, I was on mute. In this case, it did occur on April 8th, 2023. Officer Dorsey was dispatched to this incident location, which is 1271 Whittier Place, in reference to a form of a sexual assault call. When officers got there, they met with the caller, who was named Miss Julianne. She indicated to officers that she saw a person that was later identified as a defendant on top of a naked female, and that she had her pants down. Further, the warrant indicates that this incident alleged to have started because there was a verbal altercation that turned physical inside of the home. When officers went to that location, they met with the victim in this case, Miss Leilani Collier, that's Leiloni, and Collier, Collier. She indicated to officers that she also called the police, and that she went through the defendant's phone, who is in fact her husband, and saw that he was cheating, and that when she questioned him about it, there was a verbal altercation, and she went to go lock herself inside of her bathroom to avoid the defendant. And she stated that he forced his way into the bathroom and that they were tussling down the stairs. She stated that the defendant opened the door and dragged her down the street in front of another location, which was 2153 Ladon Lane. She further stated to officers that the defendant got up and left her in the street. She showed officers visible injuries that she sustained from being dragged by the defendant in this case. She stated she had visible injuries on her right leg, her lower right leg, and her back and her butt. The officers asked her about sexual assault allegations, and she stated that that did not occur. However, when we spoke to her earlier today, she indicated that she had been married to the defendant since January 2023, and that they live at 2174 Whittier Place, and that the defendant also lives in Tampa. He goes back and forth, that they don't have any children together. She stated that they have not been together long enough, and that this is the first time that this has happened. She stated that she will be filing for divorce. He was acting strange, and so she had his password, so she went through his phone and she saw, another woman confirming that she loved him, and that's what started the incident. She went to go and take a shower in the bathroom to get away from the defendant, and she was naked when he dragged her out. She stated that he slammed her body on the concrete patio floor, and they began to tussle, and they both fell down the stairs. She stated that when they landed at the bottom of the stairs, the defendant continued to drag her on the concrete floor and place his knee and weight on her chest to stop her from going anywhere. She stated that she did fight him off of her eventually and ran to her home to call 911, running down the street without any clothes on. She indicated that she sustained multiple skid marks on her body and bruising. Officers indicated also that her leg was bleeding. So for those reasons, she stated to her victim advocate that she wants no contact and to stay away from her home. Even though that this is the defendant's first offense, Your Honor, we have some serious concerns about the risk of reoffense in this case, given that these parties are married and the nature of the allegations as alleged, being that he dragged her outside unclothed and caused these injuries to her. And she believed that she was going to die, is what she indicated. So we're going to be requesting a $4,500 surety bond, no further contact with the victim in this case, stay away from the incident location as stated on the record, which is 2174 Whittier Place Northwest. No alcohol, drugs, and weapons, 2 weeks of anger management, and no further violations of Georgia law. I don't know if the victim is on the call, but the state would like the court to sound for her when appropriate.
Ms. Collier is on the line. Now is your opportunity to address the court if you choose to do so.
Yes, Your Honor.
Yes, good afternoon, Ms. Collier. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Your Honor, I've been married since January, and my husband displayed like something that I've never seen before. He was very angry. He got very physical with me. When I checked his phone, I noticed that he was acting unusual. And so I checked his phone. I had full access to his phone. He gave me full access to his phone, so I know his code to get in his phone. I went in his phone and I started seeing these messages that he thought he had deleted from a whole bunch of different women. And there were naked women on there. There was conversations between him and the other woman, stating that they had a good time the other night. A lot of sexual stuff that they had done a couple of days prior to this incident. And also I'm speaking with, when I got married to him, he had been, I didn't know that he was engaged to another woman like a week prior to marrying me.
Irrelevant.
And she also told me that he does have he has been physical with her and other women as well that he's been dating. So I am in fear. I am in fear for my life. And I don't want him around me. I don't want him, I don't want any contact with him. I want to get a divorce from him. I am scared of him. He's 300 pounds. He acted as if he wanted me to die that day. He was enraged, and I grew up in a physically violent home with my mom being abused, and he displayed that characteristic that night that I used to see on my dad's face, and I never want that to happen to me. So I am in fear of him. I know the signs of abuse when it comes to women. I also have a criminal justice degree background, so I know the signs, and he displayed every single sign that night. And so for that, I am in fear for my life.
Okay, is this do you live at the Whittier Place address?
Yes, 2174 Whittier Place.
Okay, and does he live there with you at the present time?
No, he lives in Tampa. So we never officially moved together. We were back and forth at each other's house, but he has nothing here. So he has nothing to come here for. He has no clothes, no nothing at my house.
Okay, thank you, ma'am.
Thank you.
You're welcome. Ms. Kim?
Yes, Your Honor. Mr. Albani Zeno is 47 years old, and he came here to attend the funeral on Saturday, Your Honor. My client denies the allegation. He is actually very successful IT executive. He founded the Constellation Telecom company, and he is getting ready to retire from his job right now. And yes.
Not true.
First of all, we don't, there's no interrupting people. That's not appropriate. That won't be tolerated. And, don't let it happen again. Go ahead, Ms. Kim, I apologize.
No problem, Your Honor. Thank you. So he actually does not reside here in Georgia. We have no objection to stay away from 2174 Whittier Place. And he also wants to have a divorce. So there is no conflict about that part. So it is completely okay not to have any contact with her. And we would like to request for signature on bond. This is the first one. He's got to go back to Florida and then he will come back for the court. We would like to request for signature on bond. Thank you.
Your client has his hand up, Ms. Kim. Would you like to advise him?
Unless this is directly related to the bond, I strongly recommend you to stay silent. Is it directly related to the bond?
We can't hear in courtroom 2 because you're on mute.
He wants to know if he can go back one time, Your Honor, that's all.
Or if she can just give me my items that she took from my bag. It's a workbook that she took from my bag. As she was in the street, she took it out of my bag as I was trying to flee the scene.
Okay,
She took it out of my bag and she has my workbook.
All right, you're all gonna have to deal with that on a different, at a different time. It's going to be a $1,000 good bond. No further contact with Ms. Collier. Stay away from the Whittier place address. No drugs, alcohol, or weapons while out on bond.
Could I also request that she stay away from my residences?
Well, I'm requesting, unfortunately, you're the defendant here, Mr. Zeno. I have no control over where she is, but I suggest that if you're anywhere or near that, you make sure that that you're not around her, okay? All right, good luck to you, sir.
Thank you, sir.
Let's see, before we go to the next person, Miss Militia has been trying to get the court's attention for a while now. And I don't remember which person she was here for. Are you with me now, Miss Militia? Okay, you're still having the same problem, ma'am. So if I can't hear you, then I'm not able to
Thing before.
okay.
May I say one thing? Sorry.
I'm sorry, is this?
This my name, I'm Steven. I just wanted to say one thing to my lawyer. That
Hold on, who do I have here in courtroom 2? Who is this?
this, the Malaysia, that's the one. What he said.
Oh,
the
okay.
Yeah.
Yeah, no,
yes, ma'am.
no, sir, I don't want you to say anything because I don't want you to put yourself in any.
I don't think it's gonna incriminate me, but you have to understand that, you know, my wife and this is our residence. This is my home. She doesn't live here. She has no ties to that residence at all.
Well, if she does not have any ties to that residence, I've in my order, I said that you can go back there, but if she's there, you can't be there.
Okay.
Okay.
I mean,
So if she's not, if she's, I don't know what your arrangement is, sir. I don't know if she was living there. I don't know if you're gonna have to file eviction to get her out. I don't know any of that. All I know is that if she is there, you can't go back there, but if she's not there, then you can go there. And because I can't hear her, I'm not able to get her side of what's what here this afternoon. All right, so my order remains. Who do we have next? Ms. Militia, I'm sorry, we can't, I've tried what I can do for your case, but since we can't hear you, then that can't be considered this afternoon.
Your Honor, for position,
Yes.
For position 14, you said you're going to break up with that, and then we have position number 2, Kelvin Banks, who has signed the paperwork for the plea.
Okay, can we bring Mr. Banks up?
Come on, Mr. Banks.
Okay, Mr. Banks, good afternoon again. Let me just say, you have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at these proceedings. We have provided you with the advice, if you choose to take it, of the public defender. It is my understanding that you, whoever this Marv is, can you all deal with this? Because that's distracting, coming in and out, and it's distracting the court. So I'm not sure who MARV is, but this coming in and coming out is distracting. So can we somehow deal with Marv? I'm not sure who they're here to address. Okay. I apologize, Mr. Banks. Let's see. Again, you have a right to have an attorney present at these proceedings. It's my understanding that you wish to proceed without the advice of an attorney and plead guilty to criminal trespass. Is that correct?
Yes, sir. Yes, sir.
Okay. And Ms. Falk, what was the offer on that?
Your Honor, state's offers 12 months probation, 2 days in jail, credit for time served, balance of probation suspended, stay away from the BP located at 575 Chapel Road, CHAPPELL. The defendant entered at that location on April 8th, 2023 to buy snacks, but the clerk wouldn't serve him. The officer spoke to Mr. Viravali, who is the owner, who previously told the defendant not to come to the location. And when the officers ran their information, they saw that the defendant had multiple trespass warnings, including one from that location previously.
So it's my understanding, Mr. Banks, that this is going to be a time served plea and you just can't go back to the BP gas station. You understand that?
Yes, sir. Yes, sir.
And is that your understanding of what the offer is?
Yes, yes, sir.
And is that something that you wanted to accept?
Yes.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Banks. It's my understanding that in case 23 CR 002149J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No.
You have been given the opportunity to be represented by counsel. It's my understanding that you wish to waive that opportunity and you wish to proceed pro se today. Is that correct?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Did you have the opportunity to go through the plea paperwork?
Yes.
Did you go through that paperwork line by line?
Yes.
And did you sign the bottom of the paperwork?
Yes.
Did anyone force you or coerce you to plead guilty?
No.
All right, I'll accept the plea as negotiated, Mr. Banks. Good luck to you, sir.
All right, thank you.
You're welcome. So, courtroom 2, you're telling me that the only thing we have left in your court with a waiver for Mr. Gonzalez, position number 14, is that right?
Yes, Your Honor.
Okay. And let's see, and the other people on the calendar, where is, say it again?
They have waived, position 7, Dunbar waived. And I believe the other one was Sealy.
What about Simone Gilmore, position 12?
I believe Miss PD Wills was actually working on that, and they have not made an arrangement for Miss Gilmore to be transported to defect facility. So
Oh, that's the one that
Yes.
we've been dealing with. Okay,
Yes.
so she's still waiting for her transport.
Right.
Okay. Should I? Oh, and we put this on for today so that I could make sure that she was transported.
Or
Um,
modify the conditions of bond, I think was my other understanding, if we couldn't.
Okay, I'm gonna have to, we're gonna have to come back to that one because I'm gonna need more of a, I remember what we were gonna do with her. Mr. Howard was also on the line to help us with that, right?
Right,
So, all right, so let's come back to that last, and if someone can raise Mr. Howard for me to see if he has any input on her. I know we've been working with her, and we put her on this calendar specifically so I could deal with her today. All right, so let's so it appears that aside from that case, the only other cases we have are cases that have a waiver. Is that correct?
Your Honor, I just wanted to confirm that Mr. Honore does have a waiver. I didn't see an email from defense about that one, but
Honore,
I may have just been incorrect.
Mr. Honore Dunbar, I filed a waiver for him.
Oh, okay. I
Okay.
usually get a waiver from the PD, so I didn't see one, so I wasn't sure. Thank you.
Yes,
Okay.
I have all the waivers, Judge.
Thank you, Ms. Grace. And who do we have in courtroom 2 now?
Position 14, Mr. Stephen Gonzalez. He did not we did not know that he was waived.
Okay, so who's his counsel?
I believe that's PD Wills, excuse me.
So if she sent in a waiver, can we go ahead and take him back, Your Honor?
Yes, that's fine.
Your Honor, am I getting ROR today?
All right.
Huh?
Miss
I
Miss
got a
Wells.
bar. I'm sorry. Nothing I need to understand was.
Okay, hold on, sir. Miss Wells.
May I please
Okay.
go first? I'm trying to reach her.
Okay.
Oh, here she is.
Miss Wells, are we gonna need to deal with Mr. Gonzalez in a breakout room?
Yes, yes.
Okay, so why don't we go ahead and do that? Go into a breakout room. We'll be back with you, courtroom 2. I'm sorry. So who all needs to be in the breakout room?
Myself and Miss Kim, please.
Okay, and Miss Falk, and I'm not sure, are you presenting on this one, Miss Falk?
I am.
Okay, and is there a history that I need to know about? Ms. Boxley Chester?
Defendant has one cycle out of Georgia, no convictions there. Defendant has .40 cycles out of Florida. He has a burglary of a dwelling in 2006 conviction. He had a probation violation in 2006. He has a marijuana possession over 20 grams in 2009. He has a possession of alprazolam in 2012. He has a possession of methamphetamines in 2012. Possession of cannabis, 20 grams or less, 2012. Resisting of an officer without violence in 2012. His attempted burglary of a dwelling in 2012. He has 2 FTAs in 2012. He has a misdemeanor disorderly conduct in 2022.
Okay, thank you, Ms. Boxley Chester. I appreciate it.
Your Honor, I'm also showing a June 16th, 2022 arrest out of Burlington, New Jersey for robbery, criminal mischief, and shoplifting.
Okay, thank you.
With no disposition.
Okay, and if we can go into the breakout room, please. Okay, we've had the opportunity, courtroom two, to speak with Mr. Gonzalez. His bond is going to be $1,000 good bond per charge. No further contact with Miss Sultana. Stay away from the Summit Drive location, an MHET, and no drugs, alcohol, or weapons. He'll be placed on the May 18th competency calendar. All right, good luck to you, Mr. Gonzalez.
I'm sorry, Your Honor. Can you say the date of the competency calendar again?
I have down May 18th.
Okay.
Okay.
Can you guys hear me now? Hello? No. No.
Who's speaking, please?
I can't hear something.
Oh, can y'all hear me?
Okay, I'm sorry, Miss Militia. Everyone is gone from the courtroom. Your person's not here at this point in time, so we can't take up your matter at this time. We appreciate you being here.
I know, I don't even
Okay.
know what happened. I didn't even get to I couldn't even hear. I couldn't.
Okay, I
don't
understand,
know.
ma'am. I understand, but courtroom two, we're done with Mr. Gonzalez, and we're done with courtroom two. We just have the waivers. Ms. Militia, you'll get notification of the next hearing date in the matter. Okay.
I know, but I was like,
Okay, no,
I
ma'am.
didn't-
We don't. I cannot discuss the case if the person's not before me. So I cannot have you speak at this point in time. Okay, so you'll get notification of the next hearing date, and if you choose to be there at that time, then you can be heard. Okay, but as far as today goes, we're done. Okay, I'm sorry, ma'am. We weren't able in the last 3 hours that we've been here. We were not able to get you connected so that you can speak. Okay, so let's go. Is Mr. Dunbar? He is a waiver. Is that correct?
Yes, Your Honor, he's a waiver.
Okay. Does Mr. Dunbar have a history?
This appears to be the defendant's first offense, Your Honor.
Okay. And who's presenting, Ms. Falk?
Yes, Your Honor. Mr. Dunbar, and if Your Honor can just give me 1 second. This happened April 9th of 2023 at around 7:00 p.m. The address was 1269 Prior Road. When the officers observed a vehicle at that location, they made a traffic stop, and let me see. They had been observing that vehicle at that location. My apologies. My Odyssey seized up on me a little bit. Okay, we are back on track. All right, so the officers performed a license check on a vehicle that was at that location as they were driving away, where there was an alarm continuously going off. The registration of the vehicle was suspended. They followed the vehicle for about a quarter mile. They noticed the left brake light not working, and the defendant failed to, the driver failed to signal. So the officers then initiated a traffic stop. They had the individuals get out of the vehicle. There were a number of individuals in the vehicle. One of them was the defendant. The defendant had a bag in his possession, and the officers were able to see the defendant holding the bag between his legs. He said it was his bag, but that the officers couldn't question him because he was a minor. When he was detained, he stated he didn't want to identify himself. They could see inside the bag a butt of a rifle in the bag that he did claim as his. Inside was a Kel-Tec 22 caliber rifle, $10,000 in $100 bills, and 3 scales, as well as 4 empty bottles of promethazine syrup that were found in the bag. A warrant check was performed, and it showed that on the serial number, which then showed that it was a gun that had been stolen from Cleveland PD, Georgia. And the defendant at that point was then charged with possession of a firearm under the age of 18. I believe at the time of this incident, he was 17 years of age. So he was not, in fact, legally a minor. The state's recommendation on this case, we do have some real concerns about this. One, the fact that it is a Kel-Tec 22 rifle, the fact that there was also $10,000 of cash, promethazine bottles, and scales inside that same bag that he claimed as his, and given his age, we do have some concerns about his risk of reoffense and the danger he presents to the community. So we are asking for a $10,000 surety bond, no alcohol, drugs, or weapons. And we are also asking that he stay away from the other people in the vehicle. Their names are as follows: Christian Chambers, Davon Schultz, and Mr. Quantavious Kane. So we are asking that he stay away from all of those individuals in the vehicle as well. Thank you.
Ms. McClellan?
Yes, Your Honor. My client is 17 years old. He is currently in the 12th grade at Clarkston DeKalb High School. Your Honor, my client denies that that the gun that was found was his gun, Your Honor. He has no record whatsoever. He tells me that he lives at home with his mom, his grandmother, and his big sister. And he just happened to be in the car, which was stopped, Your Honor. He said he wasn't doing anything. He was just sitting in the back of the car when it was pulled over. We know that my client doesn't have a record, Your Honor. I'm going to ask the court to consider giving him a signature bond. He doesn't really have anyone. I believe his mom may be on the Zoom, Your Honor, but he doesn't have any money to bail him out or anything. He tells me that he's currently unemployed, which is normal considering that he's 17 and he is in school.
Okay, and is this Miss Lucky? Are you Mr. Dunbar's mother?
That is correct. And first, I want to apologize for the interference earlier. I want to apologize to you and to the court for that. I am Mr. Dunbar's mother.
Okay, you're fine, Miss Lucky. Can you raise your right hand for me?
Of course.
Okay, do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Of course.
Okay, you can put your hand down. Thank you. What would you like to tell me about, what's your son's first name?
Honore.
His name is Honore.
Honore? Okay, what would you like to tell me about Honore?
You know, Honore has been troubled since the absence of his father. I've been trying to do the absolute best to raise him. I work my off to raise this young man. So I was floored when I got the news at 8-something last night. I was in South Carolina, and there was no way that I could make it back last night. I had worked I've been 6 days straight working 13-hour days, driving from South Carolina to Augusta. And he's in school. He's I don't know what I can say to you other than if you could allow me him to be released to me, I will try my best to not allow anything like this to happen again. I don't know what to do because I am so $10,000. Oh my God. I'm sorry?
I was going to say, I believe they said that it was subsequently found out that the money was not real. That was in the warrant. It was not real. Correct?
Oh God. It's you know what? It's that fake money. He's trying to wrap that. I had just had someone cash app him $25. So I'm like, 10,000. Oh my God.
Okay, so Ms. Lucky, he's 17 years old. While you're out working, and I understand that you're working, who is with him?
My mother is in the home. She's 85. Okay. My sister is in the home. She's 60. He has a younger sister who's in college at Georgia State, who's 24. This was just an exception for me to be gone this last 6 days because it was for the Masters in Augusta.
And so
It was
normally
an
you're
exception.
home also with them.
I'm back and forth. This was a rarity. I go, I'm generally in Atlanta throughout the day, and he sees me every night. This was the exception out of the year for the Masters. Honestly, I haven't been out of town without him. Yeah, in a long time. Last time we went out of town for a family reunion, and we all went together. Can you hear me?
Yes, we can hear you.
He said something about he was going to be doing a video, his first video. So I'm thinking maybe they had that fake money for the video. Haven't really had an opportunity to speak with him very much. Can you hear me?
Yes, we can hear you, Miss Lucky.
You know, I'm gonna be honest. I'm an ex-social worker, and I work with level 10 troubled kids for the Department of Justice and for the United Way for years when I was young. Every tool that I have in me, I try to instill in him. It is if you release him to me, I don't have any money to help him. He's a
Judge, you're
minor.
muted.
He doesn't have a job. I'm sorry.
Okay, I understand what you're saying, Ms. Lucky. And it's my understanding that this is his first offense.
Yes,
I'm going to, you're gonna have to sign him out, Ms. Lucky, okay? So you're gonna have to sign him out. You're also, so he's not gonna be released unless you go get him. And he's not gonna be released, and when you go get him, you're gonna have to have an identification, and you're gonna have to have an electric bill or something to prove that you live in that household. What is your address? What is the address where?
I am at 790 Edenberry
Spell
Lane.
that for me. Spell Edenberry for me.
Edenberry.
Edenberry Lane.
And then that's in Lithonia.
Okay, so you're gonna need something to prove that that you live there. A utility bill is the normal, and you're also gonna have to have an ID. We'll release him into your custody, but I'm gonna put him through pretrial. It's gonna be a $10,000 signature bond through pretrial per the judge. He is to reside at the Edenberry Lane address with you. He is to order that he's to stay in school. It will be ordered that he's going to have a curfew from 9 p.m. and he can't leave until 6 a.m. to go to school. He's not to have any further contact with these other young men that were in the car, Mr. Chambers, a Mr. Schultz, and a Mr. Kane. And of course, he's to have no drugs, alcohol, weapons while he is out on bond. All right.
Okay, so when you say pre-trial, am I allowed to go back to Rice Street now, or?
If you have all the documentation, if you have the documentation with you, you can do that, but they're gonna have to process him out. So it's gonna take a while for them to get the paperwork and with all the people that we've had today. So, but you will have to, I'm placing him into your custody, okay?
Okay, so they start the process once, they get to him, and then I bring the documents. Or do I bring the documents first?
You're gonna need to bring the whenever you process them out, you're gonna have to have the documents with you. So you'll need to get all that together so that when you do go pick them up, that you will have the documents, okay?
Of course.
All
Thank
right.
you.
Good
Your
luck to you,
Honor,
Ms.
Thank you.
Lucky. Yes,
Your
Ms.
Honor,
Falk.
if I may, two
Thank you.
things. One, I apologize for the oversight. Once I read back through the warrant after Ms. McLeod spoke, I did realize that they said that the money did feel different than real money. So I apologize for
Okay, you're fine.
omitting that fact.
Okay.
It was unintentional. The second thing is this defendant, if he doesn't have any extracurricular activities, can we move that curfew to 7 o'clock? Because this actually happened at about 7:30.
Okay, that's fine. If he gets a job, Miss Lucky, or if he is participating in any extracurricular activities, then I can extend the curfew, but he is to be in by 7 o'clock, from 7 p.m. to 6 a.m. Okay?
Thank you.
Okay, all right. I see you're doing the best you can, Miss Lucky. I understand that. Good luck to you, ma'am.
Thank you so much.
Okay,
Thank you.
you're welcome. All right. Let's see. Who do we have next? We'll put Miss Gilmore off till the end. I'm not sure if we can get Mr. Howard on the line or not. We also have
Mr. Seeley.
We have Miss Riser 25, and who's the other one? Seeley. Is that Seeley yours, Miss McLeod?
Yes, Your Honor.
Okay, so why don't we go ahead and take Seeley next? And
Judge, you're on mute if you're speaking.
thank you. Does Mr. Seeley have a history?
Yes, Your Honor. Mr. Seeley has 4 cycles out of Georgia, no convictions. And he has 2 cycles out of Maine, and he has a OUI alcohol conviction in 2017 and a violating condition of release in 2017 out of Maine. And nothing further, Your Honor.
Thank you, Ms. Duncan.
Yes, Your Honor, this defendant does have an open felony criminal trespass that was a burglary that was reduced to felony criminal trespass. 22 CP 215045. And this defendant also has an open burglary in the first degree. 23 CP 216300. That incident location is similar, if not the same apartment complex as the incident before the court today. He was just granted a $5,000 good bond with an ankle monitor and released to proper recovery on February 15, 2023 from the ORCA calendar. And this offense did in fact occur on April 8th, 2023 at 2591 Piedmont Road. Officers went to this location. They were dispatched there to the Peninsula at Buckhead Apartments. They spoke with one of the security guards, and Mr. Dominique Freeman, who indicated to officers that he had received a call from management about 2 individuals occupying vacant apartment units, specifically unit 1111. Mr. Freeman, the security guard, escorted officers to that unit, and upon arrival at the unit, they checked to see if the door was open. However, it was locked. Officers were finally able to make contact with the occupants of the apartment, and one of the persons was later identified as the defendant in this case. And when they attempted to make contact, and they ordered the suspect, who was later identified as the defendant, to walk in their direction, he objected and began running and started a foot chase through the parking lot of 2525 Piedmont Road. Officers were eventually able to gain ground on that suspect, who is the defendant, and bring him to the ground to detain him. And during that process, Your Honor, they kept trying to identify this defendant, and he kept giving the wrong name. He kept giving the name of Jack Burnham, and an incorrect date of birth being September 8th, 1991. Both of those items of information were in fact incorrect. The other person that officers identified at the location was DeMarcus Stanford. He was at another apartment when officers were able to make contact. I did want to note for the record that this defendant, that other person that was with this defendant had been previously arrested on a criminal trespass on April 4th of 2023 and was subsequently released, and a couple days later committed this offense with the defendant who is before the court today. The state does have some concerns given that this defendant does have that open felony criminal trespass that was in fact a burglary reduced, and that open burglary, as stated on the record, given that he was in this location without permission, and they in fact indicated that he had damaged the utility doors on that unit and locked it up and kept the leasing persons out of that unit. For those reasons, Your Honor, given those open cases, the nature of the offense alleged, and this defendant's history, we have concerns about the risk of reoffense and the likelihood to respond positively to the legal process. Therefore, the state is going to be requesting an $8,000 total surety. I do want to further indicate that as far as when they took him into arrest and they searched him, they did find a clear glass round tube with a ball attached, so a pipe that they believe to be used to inhale crack cocaine. And so we're asking for $8,000 total surety, $2,000 per criminal trespass count, and $1,000 for the other counts. If my math is correct, that would equal up to $8,000 total. Stay away from the incident location, as I do believe this location and the open burglary case is the same location, because the officers did indicate that he is a possible burglary suspect as well. No alcohol, drugs, and weapons, no further violations of Georgia law. And stay away from the other party involved in this incident with DeMarcus Sanford.
Ms. McCall?
Yes, Your Honor. My client is 29 years old. He tells me that he is currently an inpatient at Purple Recovery in Gwinnett County, Your Honor. He's been there for several months now. He said he had an issue when in the psychosis and he had to be taken to Gwinnett Medical. I think he was at Gwinnett Medical and that was where he left from. I think he ought to have been in some kind of supervision, but he wasn't. So he kind of wandered away, Your Honor. My client is still in recovery. I just want to put that out. And he does want to go back to Purple Recovery, Your Honor. So I would ask the court to give him a signature bond conditioned on him returning to Purple Recovery, because he's still actively in rehab, Your Honor, and he does recognize that he needs that. He does not work at all, Your Honor. He's unable to do so. So he's not in any position to post a bond.
All right, so it's going to be a $500 good bond on each charge, makes it a total of a $3,000 good bond. Ms. McLeod, if he is still in by the SAP calendar on April 25th, if you will get more information on where he is in recovery and him being transported to recovery, I'll reconsider this bond if you would like for me to do so. But if he's going to go somewhere, I'd like to, number one, make sure that he's actually there and that we have some transport for him if he wants to get back into recovery. A stay away, a no further contact, and no drugs, alcohol, or weapons while out on bond. But again, I'm happy to seek a modification with those terms that I just articulated. Okay.
And I just want to ask for the court, the prior burglary that's open, Your Honor, he was released with an ankle monitor, so he does still have, I'm assuming he still has that ankle monitor, so we will request that that remain intact as well.
Okay, well, that will remain in that case. As far as this goes with the charges, if he's on a main ankle monitor, he's going to have to stay on it. but it's not going to be a part of this order.
Understood.
Okay, all right. So that takes care of that one. I think that we also have position number 25, Mr. Reiser.
Yes, Your Honor.
And does Mr. Reiser have a history?
Yes, Your Honor. The defendant has 82 cycles. I'm just going to do the earlier cycles. I can go back to 82.
Okay.
He has a criminal trespass conviction in 2011. He has a failure to appear in 2011. He has a marijuana possession less than 1 ounce in 2011. He has 2 aggravated assault convictions in 2012. Probation violation in 2012, another probation violation in 2015, and an FTA in 2017.
And nothing since 2017?
Nothing that is in this decade.
Okay, all right. Thank you. Ms. Duncan?
Yes, Your Honor. I would like to state for the record that I did see that this defendant had an open, I believe it's a magistrate court case for theft by shoplifting and possession of marijuana less than 1 ounce from 2022, and a 2017 open magistrate court case for possession of drug-related objects. I'm still currently researching the status of those cases, but they were showing as open on Odyssey for this particular defendant. This incident occurred on April 7th, 2023. Officer Lindsay was working an extra job at the racetrack located at 120 Piedmont Avenue Northeast, and they observed a male who he was able to identify in the past from giving him a previous criminal trespass warning as a defendant in this case. The defendant was observed in the parking lot approaching multiple customers, asking them to give him money. He was taken into custody and arrested and charged for criminal trespass because he had previously been told not to come back to that location. For these reasons, Your Honor, the state does have concern about the risk of reoffense. We have, given that he had a previous criminal trespass from this place, we have been concerned about his flight risk, given that recent FTA and his likelihood to positively respond to the legal process. As pretrial indicated, this defendant does have 83 cycles. It is for those reasons, Your Honor, that the state is going to be requesting a $1,500 total surety bond and stay away from the incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Ms. Kim?
Yes, Your Honor. Mr. Reiser is 67 years old, Your Honor, and he has a part-time job. He's been gainfully employed for the last 5 years at Atlanta Smoke Shop as a team member. Since it is a part-time, he does not have enough bonds, so he is qualified for public defender services, Your Honor. He also has a need for the housing, so social worker is already notified, and hopefully he will be in contact with him to provide housing resources. Your Honor, he does not have any financial resources at this point to pay for the bond. We would like to request for signature on bond. Otherwise, right now there is a $1,000 good bond for criminal trespass. We want it to be set as is. It doesn't have to be increased to $1,500, Your Honor. Thank you.
And I neglected to add to the record, Your Honor, I did see an open aggravated assault. It was 04 CP 21609, and that the MAGCOR case I was speaking about, that's 220532, just for the court's edification, nothing further.
Okay, I'll leave the bond where it is, $1,000 good, stay away from the racetrack, no drugs, alcohol, or weapons, and a social worker visit for housing. Okay?
Yes.
All right, I think the last one that we have is Ms. Gilmore. Let's see. I'm not sure what we can do with Ms. Gilmore this afternoon. Do we need to just put her on another calendar? Do we have, I don't even know if we have a reason that she hasn't been hasn't been escorted as of yet?
Yes, so I've been in communication with DFACS. They are unwilling to transport her themselves. And so they have to find a transporter to take her to the mental health facility. The last I heard from them, which was last week, they told me that they had reached out to 97 providers and no one responded. I reached out again to them today. The supervisor responded and I asked her to if she could join the call. She said she was unable to, but I don't have any other updates other than that.
Well, I believe, if I'm not mistaken, that last week they told me that they would take her. Did something change?
Well, they will pick her up, but they are only willing to go through a third party provider that they use.
Okay. So what do we need to do, Ms. Wills?
At this point, I'm not really sure, Your Honor.
Okay, so why don't you get in touch with Mr. Howard and see if you all can come up with something between the two of you so that we can get this young lady transported. I don't know what that would be, but maybe he has some ideas. I don't know. I'm not on the calendars the rest of the week, so I guess you'll have to, I think Judge Lowell has this tomorrow. Do you want to reset it for tomorrow?
If she's not taken there, I would prefer that. I'm not sure why. I don't know if they could Uber her, but the issue is she can only be released to DFACS or someone that they authorize. So I'm not sure. Yeah.
Okay, I guess it's not an issue if they transport her. I just don't want her to sit. Ms. Falk, are you are you with me tomorrow at the Orca jury trials or not?
I am not.
Okay.
I am going to be here. I can handle this one on our end, on SCA side. What I would say is there are times when you can order the sheriff's office to transport someone instead of the jail to come pick someone up. But I will say, having experience doing those orders, they have to be very precise, as in down to the time, down to who you're releasing to. They have to have a contact person. They have to be extremely precise for the jail to be able to execute it.
Permission to speak, they don't do that anymore because it's a major issue with transporting, because technically they're not in a sheriff's office custody anymore at their time.
Okay, so we did one about 8 months ago, so that may have changed.
Okay, so Ms. Wells, if you get together with Mr. Howard, and if you all can come up with something, and if you all want me to intervene, or I'll be around the rest of the week. I'll just be in the Orca calendar, and I'm happy to help you all deal with this, or to sign any orders that you want me to sign, or whatever it is that I need to do. So, you can get to me through the clerks. So if you all work it out with Ms. Falk and Mr. Howard, then I'm happy to sign whatever it is that you all need me to sign. If you need me to sign something to help you out with this, okay?
I really appreciate that. Thank you.
Thank you.
Okay. All right. And I'll be in G33, so you can always just stop by. Let's see.
And we're resetting it, Judge?
Yes, why don't we just, I guess we reset it for tomorrow. And
Okay.
if you all are able to work something out and you need my assistance, then you know who I am. If before the SEA calendar, okay? Okay, does that conclude today's calendar? I hope so.
No, let's keep going. Let's keep going.
All right, so Ms. Grace, whenever you're ready, I think everyone else is ready also.
We've been ready.
Okay.
Position number 1, $5,000 pretrial bond. Position number 2 was a plea. Position number 3, $3,000 pretrial bond per judge. Position number 4, sign-on bond through the jail. Position number 5, $3,000 pretrial per judge. Position number 6, $3,000 sign-on bond through the jail. Position number 7, 10,000 pretrial per judge. Position number 8, 3,000 pretrial per judge. Position number 9, 2,000 good bond. Position number 10, 5,000 pretrial per judge. Position number 11, $2,000 good bond. Position number 12, reset for tomorrow's SEA. Position 13, $2,000 good bond. Position 14, $2,000 good bond. Position 15, 2,000 pretrial per judge. Position 16, 5,000 SOB jail. Position 17, 5,000 pretrial per judge. Position 18, 1,000 SOB jail. Position 19, $1,000 good bond. Position 20, $500 good bond. Position 21, 3,000 pretrial per judge. Position 22, 500 good bond. Position 23, 21,000 good bond. Position 24, $3,000 SOB jail. Position $25,000 good bond. Position 26 was transferred to Superior Court. Position 27, 3,000 pretrial per judge. Position 28, 3,000 good bond. Position 29, 2,000 SOB through jail. Position 30, 1,000 good bond. Position 31, 1,000 good bond. Position 32, 3,000 pretrial per judge. Position 33, 1,000 good bond. Position 34, which was Harper, 2,000 good bond. And that completes it.
Two questions. What is
Yes.
the reset date and what's the amount for position 4?
The reset date is April the 25th. And what was the other question?
Position 4, what's the amount?
Position 4, 2,000 SOB through the jail.
Thank you.
And Miss Grace, did you get the transfer order?
I received everything from everyone. Thank you.
Thank you, Miss Grace.
No problem.
See you, Jay. I appreciate it.
And I'll be sending it over right now, Judge. Thank you.
Okay, thank you. And Miss Bridgewater, good to see you.
You all go home and exhale, okay? See you tomorrow.